to the tribunal. The registry is transmitted to transmit the case records. I'll do the pages later, okay?
For judgment, item number 2.
The petition is dismissed.
I just want to mention one item, my lord.
Yes.
Sorry that I could not be present today because I'm suffering from back problem.
Yes, which matter?
Item number 3, my lord, because they have filed a reply today in the morning. It has been served to my junior who is present there.
Okay.
So once the reply, we have to look into it, and we have to give a rejoinder to that reply in respect of an interim order, which we are seeking for. So if it is not inconvenient to your lordship, can it be fixed after reopening of the court? Because now vacation will start.
Yes.
So only on 21st, if it is not difficult for your lordship, 21st of July. I have already spoken to the other side, Mr. Gupta, yesterday itself.
21st?
July, my lord, it will be Monday.
July, yes, it's a Monday.
Yes. Thereafter, we will file a rejoinder and we will serve an advance copy to the other side.
Yes, yes. Senior counsel, Mr. D. Das, for the petitioner, has submitted that they have received a copy of the reply from the respondents only this morning and would like some time to file a rejoinder to the same. Mr. D. Das, assisted by such and such. His name. Yes. Learned counsel for the respondent is represented by Mr. YP Gupta is represented by Miss. Yes. Accordingly, list the matter on 21st July, before which date the pleadings will be exchanged.
Yes, and then interim order will be considered on that day, my lord.
And the interim order shall be considered on the next date.
Sorry for the inconvenience. I could not be present, my lord. Sorry for the inconvenience.
Okay.
I'm deeply obliged.
Yeah, but this one, Lordship, I have to mention item number 16, hearing item. This matter will be released on 23rd, next Monday.
Your Lordship, apparently my senior colleague is also a little unwell, plus we have 14 and 15, which may take the whole day, Your Lordship, so maybe fix on 23rd as requested.
As prayed for by the learned additional AG, Mr. M.T. Limsong, list the matter on 23rd June for hearing.
My lord. Bless you, Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item number 17. Your Lordship may kindly grant 3 weeks' time, Your Lordship.
3 weeks' time for?
Hearing, Your Lordship.
Here for the petitioner.
Yes, Your Lordship.
List the matter after 3 weeks under prayer of the learned counsel for the petition, such and such. Learned counsel for the state respondents, Ms. S. Mary is present. Yes.
Oblige, Your Lordship. May I please, Your Lordship? Lordship, I beg to mention item number 11.
11.
Yes, Your Lordship. On behalf of Ravi Shankar. He has some personal difficulty today. So kindly list this matter on 26/6/2025.
List the matter on 26 June 2025. On the request made by the learned counsel, the Krilo, on behalf of
Ravi Shankar.
Ravi Shankar. Learned counsel, CGC is absent.
Lordship, I have taken the consent.
Okay. List on 26/6.
Lordship, there is interim.
The interim order passed earlier shall continue till the next date.
Oblige.
Please, Your Lordship.
Yes.
Lordship, I beg to mention item number 18. It is a fixed item. Lordship, the
Yes. What happened?
leading counsel is in bereavement. So let it come up after 2 weeks, Lordship. the leading counsel.
Okay, learned counsel for the appellant, Mr. C.D. Rongsung submits that the leading counsel is in bereavement and accordingly to praise for list the matter after
2 weeks, Lordship.
2 weeks.
Give
Praise
the
and
oblige.
list after 2 weeks.
Give the oblige.
Lordship, I beg to mention hearing item number 19.
Hmm.
Let this matter maybe can come out after vacation.
No list after vacation and the prayer of the learned counsel for the petition.
Keep your wish. For admission, item number 4.
My lord,
Yes.
the peruse the last order, the government has sought some time to take instructions.
Mr. L.T. Sangam.
Your leadership, as far as this petition is concerned, on the same issue, there's already a civil suit which has been filed.
Hmm.
So this petition may not detain this court much longer, if I may make the submission, Your leadership. In fact, I mentioned that in my affidavit in opposition
Hmm.
at page 2, Your leadership, in my affidavit in opposition.
Affidavit of R4.
Yes, Your leadership,
Yes,
the affidavit of R4,
Page.
page 2. The petitioner has filed civil suit number 1 of 2024 in the Court of Civil Judge Junior Division in relation to the issue of chieftainship of
Hmm.
Tilakha village. That is the same issue raised in this
In this
petition.
petition.
Yes. So what the petition is challenging here, Your leadership, is the formal order which is issued by the government. In the Sema villages, Your leadership will appreciate the through customs, someone ascends to chieftainship.
Yes, yes.
That name is submitted to the
Then after
government.
that, the government
Yes,
will
the
issue.
formal order. Now, what the petition is challenging is the formal order, but the basis of that order is in the civil suit. So filing
Same
this
issue,
petition,
same
yes,
issue.
filing this petition, it has no meaning as far as this honorable court is concerned, Your leadership.
if I may, lordship. Lordship, if the government is
Yes.
not filing any affidavit, this may be listed for admission hearing, my lord.
Yes, filing our.
No, if it's the same issue, then
Yes. The same issue.
anyway, you take proper instructions then. At least let them take some instructions. Who will appear? Mr. L.T. Samtam?
On coming Monday then, Your leadership.
That will be 23rd.
Yes, Your leadership.
23rd is okay.
Okay.
Learned Government Council, Zimomi has prayed for. Zimomi, no?
Yes.
Yes,
Reason-
has prayed for 1 week's time on behalf of Mr. L.T. Sangtam, additional AG, to receive instructions and to file a reply if so advised. Learned Counsel for the respondent number 4 is present. Mr. A. Zimomi is present, and Learned Counsel, Mr.
I, Jamir.
Jamir for the petitioner is present. List the matter on 23rd.
Much obliged.
Obliged.
For admission, item number 5.
Yes, Your Lordship.
Yes.
I have instruction to appear for my senior Aliralo. I have instruction that my client is indisposed, so we could not get proper instruction. And for respondent number 3,
For 3, no?
yes, kindly grant us
Mm.
3 weeks time.
Okay. So you have not filed the affidavit, that means,
No, we have not.
Learned Counsel, Ms. such and such, appearing for the respondent number 3, submits that the respondent number 3 is indisposed and accordingly, she has not been able to receive proper instructions in order to file the affidavit in opposition, and therefore prays for 3 weeks' time to receive instructions and to file the affidavit in opposition on behalf of respondent number 3. So prayer is allowed. Learned Counsel for the petitioner is absent. Learned Government Advocate V. Jimomi appears for the state respondents. State respondent is number 1. Respondents number 1 and 2. Prayer is allowed, list after 3 weeks.
For admission, item numbers 6 to 10. Also, here the state respondent is yet to file affidavit in opposition, Lordship. If Lordship may please grant another 3 weeks time, Lordship, to file affidavit.
Lordship, Lordship, in this batch of writ petition, we are challenging the order passed by the DC. And the DC order has been passed pursuant to an order passed in first appeal. And I just wanted to bring to the notice of this court. The order passed in the first appeal was passed by your Lordship as a principal district judge.
Okay.
This is a land relating to the Burma camp.
Then
So,
in that case,
whether this
we
court,
will be
this
able
bench
to
can take up or not, I will leave it to your Lordship.
Which is the order? Let's see.
The order has not been annexed, but I have a
FA.
yeah, Lordship. We have ordered the declaratory suit that is annexed, but the FA is not annexed. I have this
So on the basis of that FA order, this impugn order was passed.
June order was passed. I have the FA with me.
Okay, I remember this. Yes, I think it will have to go before another.
Lordship.
This matter before another bench without me.
Obliged.
Obliged.
For orders, item number 12.
Please, your
You're
Lordship.
for the petitioner.
Yes, my Lord.
You were supposed to take steps.
Yes, I served the notice on,
1, 2, and 3.
yes, Your Honor. I served the notice on 19/05/2025.
Learned counsel for the petitioner, is such and such is present. The notice upon respondent 1, 2, and 3. No, the return service reports on respondent number 1, 2, and 3 is still awaited. On respondent 1, 2, and 3.
My Lord, kindly allow me thus the.
Wait for some time because they have sent only on 12.
Okay,
From office note, it has been sent only on 12th
Thank-
of this month.
my Lord.
So just wait for some time. Next
my
occasion
Lord.
maybe.
For orders, item number 13.
May I please, Lordship? Lordship, I have a prayer, Lordship. Lordship, allow me to withdraw the present appeal because we haven't implemented some necessary party.
Lordship, I have serious objection to that because the prayer made today is on the basis of the objection that I have filed. I have raised that very question, Lordship, because non-joinder of necessary parties. Because before the tribunal, there were 4 claimants, but against only one of them, they have filed the appeal. And I have the
Same case.
Same case,
Case
Lordship,
for
same,
claimants.
yes. They had ample opportunity. That is one of the ground that I have taken in my written objection, Lordship.
My prayer is that, Your Honor, Lordship, an opportunity should be given to the appellant in the interest of justice. My Lord.
Sufficient opportunity has been given, Lordship.
You can file an IA also.
For implement,
Yes.
implement,
For implement.
Lordship, that can be done.
You can file for implement.
But whether that is possible, Lordship, because that is
See, let's see the original print.
Lordship, The report perhaps may not have come.
Okay, then here in the petition.
Lordship, in the judgment, now what?
Here claimant is respondent number 1. Then in the judgment. Okay. 1, 2, 3, 4.
4 of them, Lordship. 4 claimants were there. 2, 3, and 4 are the minor children of the deceased. And 1 is the wife of the deceased. Now against 1, they have come. And they have not mentioned anything about it.
These are technicalities, actually not on the merit.
Lordship, I agree with that, but then there is another ground which I've raised with it. Because they have not come with a plain hands, Lordship. Because, Lordship, on June 2024, an execution case was already filed. And number of notices were issued and finally ended up publication in the newspaper. Even then they did not agree. And not a whisper in the main appeal nor in the.
That is not mentioned.
Yes. It has not been mentioned. So purposely, the appellant has suppressed those facts. In spite of the
And
fact.
on what ground have they come this time? This appeal on what ground?
Lordship, no proper ground. I couldn't see any ground, Lordship. There is no good ground of appeal.
Anyway, if you want to withdraw, we'll allow, but all these points you can take up when they file afresh also. You want to file afresh with Liberty
Lordship,
or,
Lordship,
allow me to, Lordship,
yes,
if I may be given opportunity to file an IF for implement of the
no, you withdraw it and then you file afresh.
Lordship.
Lordship, in that case, I will be losing a good ground of defense. Lordship, 4 of us have already
No, you
suffered
can
enough.
raise that, you can raise that in the next petition also, saying that they had earlier filed this, it was withdrawn, allowed to be withdrawn, that you
That
can.
will only
say-
prolong. Peace, Lordship.
It may prolong a bit.
Because the 3 minor children and the
To
wife,
be-
they have already suffered enough.
To be fair.
Now, after they have received my objection, Lordship, the Delhi, they will come up with so many grounds, which I have pointed out in my written objection.
A delay in filing the appeal.
Yes. There are so many days of delay and no proper explanation has been given.
Okay, let's list it for admission after a week then. You take proper instruction. I think after filing objections, after filing the reply,
Yes.
I think it's not
Whether
proper.
that is
It's not proper.
would be permissible under the law.
This after 1 week for admission hearing.
Obliged.
For hearing, item numbers 14 and 15.
To these judgments now, we just wanted to compare on the side. Acha, who's appearing? Was this matter heard before?
Yes, Your Leadership. It was heard by Honorable Mr. Justice Michael Jothan Kumar
And then
and then
released,
released.
because I see all these notes. So many notes.
Yes.
Why was it released? No time.
Yes, Your Ladyship, no time.
I hope this is not another marathon, 3 day, 4 day hearing.
Possibly not, Your Ladyship, possibly not.
Because the matter may be simple, but when the facts are too much, then it gets.
Facts are quite abundant. Your
Yeah,
Ladyship.
when the facts are too much, then it gets very difficult for the court also, no? Acha, anyway. There's a recast petition.
Yes, Your Ladyship, there's a recast petition.
Yes.
During the pendency of the writ petition,
Hmm.
the petitioner died. So his legal heirs were brought on record, Your Ladyship.
Okay.
Can you go straight to the fact and the
Yes.
please, Your Ladyship? The writ petition at page 6, paragraph 3.
We are now on WPC 192.
Yes, 192 of 2016. In this case, the area of parties are, Your Ladyship, the state of Nagaland is 1, 2, and 3, principal of these officials, respondents, and the respondent number 4
Hmm.
is an association. At page 5, Your Ladyship will see the name of the association. At page 5, the Nagaland School Education Administrative Officer Association. Has Your Ladyship got that?
Yes, yes.
Yes. So 3 official respondents, and the 4th is an association which is opposing my service. It is not an individual leadership, it is an association that is opposing my service. So that is the first point which I would like to make, leadership. And page 6, Your Ladyship, paragraph 3. A,
Hmm.
by letter dated 31/3/88, inter alia, one post of Assistant Engineer Electronics, Class 1 gazetted was created in the Directorate of School Education under its Educational Technology Cell. The said post was advertised for recruitment through the NPSC. Can we go through this affidavit, Your Ladyship, at page 21? This document at page 21.
Yes.
21st March 2088,
Hmm.
to the Director of School Education, Nagaland, Kohima, subject creation of temporary posts under Educational Technology Program. Sir, I am directed to refer to your letter dated such and such on the above subject and to convey the creation of the Governor of Nagaland to the creation of the following posts in the scale of pay indicated against the post, plus all other allowances as are admissible under rules from time to time for the Directorate of School Education, Nagaland, with effect from the date of filling up the posts up to 2289. Now, the post that we are talking about is at serial number 1, Assistant Engineer, Electronic, Class 1, gazetted. So this was a post, and the 2 other posts, these were posts created for the Directorate of School Education. The language of the notification is very clear, Your Ladyship, and it is an act of the government. Then, at paragraph B, the post was advertised, Your Ladyship. I don't have that advertisement, but it was advertised. The petitioner applied for the post advertised and was recommended for appointment. Pursuant thereto, by notification dated 18/4/90, the petitioner was appointed as Assistant Engineer, Electronics, ET-Cell. The document is at page 22. At page 22.
18/4.
18/4/22, yes. 18/4/90. On the recommendation of the NPSC. Now, Your Ladyship will kindly note, this is not a temporary or a stopgap arrangement. This is by the NPSC on the post being advertised. The Governor of Nagaland is pleased to appoint Shri Lima Wabang Iyer in the post of Assistant Engineer, Electronics, ET-Cell. So there is an ET-Cell in the Directorate of School Education. School Education, Nagaland, Kohima, Class 1 gazetted in the scale pay of such and such, plus all other allowances as admissible under rules in force from time to time with effect from his taking over charge. The appointment is made on temporary basis and may be terminated with 1 month's notice from either side or with 1 month etc. So by this order, the petitioner was appointed on regular basis, pursuant to selection by the NPSC.
Yes.
Then paragraph C. Accordingly, the petitioner joined service in the aforementioned capacity under the Department of School Education on 18/4/1990. The appointment of the petitioner was in the aforesaid post was in the grade of assistant director. Kindly note this, Your Ladyship. It was in the grade of assistant director. Mark the pay scale, okay? Pay scale is that? Give me a minute, I'll look into one document.
How do we find that it was in the grade of assistant director?
On the basis of the status, which is class 1 gazetted.
The space scale pay.
Yes, and the pay scale. The appointment itself also says class 1 gazetted. And I'll come to the rules later, Your Ladyship, to point this out. Then paragraph D. Thereafter, by notification dated 24/10/2003, the post held by the petitioner was upgraded to Executive Engineer Class 1 gazetted and designated as Systems Analyst. By this notification, the petitioner was upgraded / promoted to the grade of Deputy Director. And the document is at page 23. 23. The Governor of Nagaland is pleased to order upgradation of the post of Assistant Engineer Electronics held by Sri Lima Wabang Iyer on the Education Department to that of Executive Engineer Class 1 gazetted, along with the incumbent and also designated as Systems Analyst in the scale of 10,000 to 15,200 plus all other allowances as are admissible from the rules in force in Nagaland from time to time with effect from 9/10/2003. This is used with clearance of so-and-so departments. Now, Your Ladyship, is a copy of the old rules available before Your Ladyship? The rules of 2002. Because I filed copies earlier. The Nagaland School Education Service rules of revised rules of 2002. I can supply another copy otherwise. I'll supply another copy.
Not there.
Now, in this, at Schedule 1, page 11. Page 11. Your Ladyship will see the scale pay for Deputy Director, 10,000 to 15,200. Has Your Ladyship got that?
Deputy Director, serial number 4.
Yes. 10,000 to 15,200. Has Your Ladyship got that? And Your Ladyship will see that in my appointment order, page 23. This is the scale pay. 10,000 to 15,200.
10,000 to 15,000.
Yes. Now, the state, Your Ladyship, very interestingly, the state seems to be all out in responding in favor of the association. And they're even disputing the status which was given to me as Assistant Director and Deputy Director by way of affidavits. But the law is clear, Your Ladyship. What is stated in the order is relevant. What is stated in the affidavit, which adds or detracts from the orders, that is not relevant. The point is, Your Ladyship, I was appointed, the post I was holding was upgraded to Deputy Director. And the records, the orders clearly established that. Then at E, back to the petition, Your Ladyship. Considering it expedient, the Department of School Education undertook the exercise of revamping and restructuring the directorate.
Yes.
Considering it expedient, the Department of School Education undertook the exercise of revamping and restructuring at the directorate, district, subdivision, and circle levels. This exercise was undertaken by notification dated 21/7/11. Inexplicably, in this notification, the post of systems analyst has been categorized as ex-cadre. Now, this document is at page 24. It begins from page 24, and the relevant entry is at page 44. The Lordship got page 44
Yes.
and the serial number 14
Joint directors.
is joint director, senior grade 1. The post shall be filled by promotion of the senior-most members from the confirmed members of the service of ex-cadre of planning and vocational education, including system analysts. So by this notification, this exercise, the post which I was holding was sought to be made an ex-cadre post. This is one of the challenges in my petition, Your Ladyship. Then, coming back to the petition, Your Ladyship, at paragraph F. Dated 2/9/11, my notification dated 2/9/11, the petitioner, along with others, were allowed officiating promotion in various grades. The name of the petitioner appears at serial number 3 in the said notification, and he is shown promoted to the post of joint director. The said notification amply demonstrates that the petitioner was promoted against a regular cadre post. Now, this is at page 59. The restructuring was 21/7/11, Your Ladyship. 21/7/11, and the promotion is 2/9/11. 2/9/11. And Your Ladyship will see, it is not as if the petitioner alone was promoted. A huge number of employees are promoted, all against the newly created posts. By the newly created posts, by the notification of 2011. As many as, if your Ladyship will see the number of posts created, Your Ladyship will see that at page beginning from page 24, Then 24 is the body of the order. Then Annex 1, detailed statement of, at page 27. At page 20, detailed statement of post creations and the revamping and restructuring of the Department of School Education as principal director, etc., etc. Then next page, Your Ladyship, detailed statement of post upgradation and the revamping and restructuring of the department. So joint director to additional director, number of posts, 3 posts. Then deputy director to joint director, 8 posts. District education officer to district education officer, 11 posts. Higher status, Your Ladyship. Assistant director, 8 posts. And whole huge number of posts in different categories. So it was not only my post which was upgraded, Your Ladyship. Many posts. And page 59 now, Your Ladyship. If you can turn back to page 59. This is dated 2/9/2011. My name is at serial number 3. But the body of the notification states, in the interest of public service, the Governor of Nagaland is pleased to allow officiating promotion to the following officers, to that of Joint Director, District Education Officer, Class 2 gazetted under School Education Department in the scale pay of such and such, plus all other allowances as are admissible under rules from time to time with immediate effect. So these persons were appointed in the Department of School Education. There can be no doubt about that, Your Ladyship.
Against these upgraded, newly upgraded.
Yes,
posts.
yes. And my name is at serial number 3. Lima Wabung, Deputy Director to Joint Director, post upgradation. And Your Ladyship will see the number of candidates who were given post upgradation. The person at serial number 4, the person at serial number 6, 7, 8, 9, 10, 11, 12, 19, the entire page after that, Your Ladyship. Then at page 60, the official promotion is made against the post-creation upgradation order, the restructuring notification, 21st July 2011. The official promotion is issued on the condition that the officer obtained B.Ed within 3 years as an exceptional case. Further, the next promotion will not be considered unless the officer obtains the requisite qualification as per the service rules or school education. The official promotion is made purely on temporary basis and subject to regularization by the DPC. This is what is important, Your Ladyship. Subject to regularization by the DPC. So all these persons who are promoted, their promotions will be regularized by the DPC. Then paragraph G at page 8, Your Ladyship. In the year 2012, by memorandum dated 27/1/12, the department published a tentative seniority list of its officers. In this seniority list, the name of the petitioner at serial number 19 in the grade of joint director. A perusal of the seniority list indicates that the petitioner is holding a regular post, cadre post under the department. Now, this is at page 62. At page 62. '62 is not very clear. The type copies at page 63, Your Ladyship. This is the memorandum.
Tentative seniority.
Type copies at page 63. This is 27/1/2012. Tentative seniority list of officers under elementary and school education as on 31/12/2011. A tentative seniority list of officers under elementary and school and secondary education as on 31/12/2011 is hereby circulated for information of all concerned as per list enclosed. The list has been prepared after carefully examining relevant documents available in the department. Any objection, complaint against the entries in the list should be submitted through representation supported by documentary proof to the undersigned within 30 days from the date of issue of this memorandum. If no representation is received within the stipulated time, this seniority list will be treated as final. Now, in this, I have enclosed the relevant page at page 64, Your Ladyship. I am at serial number 19. Engineer Lima Wabang Aya, BSc Electronics, year of graduation, date of first joining service, 2/9/2011, and my name is known as Joint Director. Leadership, kindly note that, Joint Director. And just above me, there is one person whose name is shown as ex-cadre.
Serial 18.
Yes, serial 18. Serial number 18. This is relevant, Leadership. This is relevant because I was not in an ex-cadre post. Someone else was in an ex-cadre post. And the documents, the orders issued by the state respondents themselves establish this fact. Then, at page 9, Your Leadership, paragraph H. The DPC was convened in the year 2012 to consider promotions for departmental officers, and by notification dated 14/8/2012, the officiating promotion of officers in various grades was regularized. The name of the petitioner is serial number 10 in the said notification. Page 66 here, Your Leadership. Page 66. This is notification dated 14/8/2012. In the interest of public service and on the recommendation of the DPC, kindly note the language, Your Leadership. On the recommendation of the DPC dated 3/8/2012, the Governor of Nagaland is pleased to order regularization of official promotions of the following officers under School Education Department as per detail given below. Now, my name is at serial number 10. At serial number 10. Has Your Ladyship got that?
Yes.
Engineer Lima Wabang Iyer, Joint Director, regularized post. Kindly note that, Your Ladyship, regularized post. So I was first regularized as assistant engineer, system analyst, and joint director. So from assistant director to deputy director to director. Has Your Ladyship got that? And quite interestingly, in the earlier document where someone was promoted as ex-cadre, the person is serial number 8. This person is serial number 9 in this DPC. And no mention is made that he is ex-cadre. But still, he also has been regularized. His promotion has been regularized. Then, if you can turn back to the body of the petition again, Your Ladyship, at paragraph I. Subsequently, by notification dated 9/6/14, the petitioner and another were promoted to the post of additional director. A perusal of the said notification would show that the petitioner's promotion is a cadre promotion. This is at page 71 now, Your Ladyship. Has the Ladyship got it?
Yes.
This is 9 June 2014. In the interest of public service, the Governor of Nagaland is pleased to allow officiating promotion to the following joint directors to that of additional directors, class 1 gazetted, under School Education Department in the scale pay of pay band such and such, plus all other allowances as are admissible under rules from time to time with immediate effect. Shri Zaputo, additional director, promoted to Shri SE. Shri so and so, number 2, the officiating promotion is made purely on temporary basis and subject to regularization by the DPC. The official promotion is subject to define. This is subject to the final judgment and order that may be finally passed by the Honorable High Court in WPC number 193K of 2013. This is not actually the one, Your Ladyship, but where's the additional director to promotion? There's a mix-up in the.
This is also a promotion
Yes.
to additional director.
Yes, Your Ladyship, but this is for someone else.
No, your name is there, serial number 1.
Ah, yes, in my copy it is clear. It is a little washed up, Your Ladyship, so I didn't see it very well. Sri Rima Babang Iyer, Vice Sri Zaputo, additional director, promoted to director SE. So me and another person were promoted to additional director. Now, then paragraph J now. Now we are coming to what has happened and what, because of what, which has prompted me to come to this Honorable Court. Apparently, the promotion of the petitioner, paragraph J.
What is this WP 193 of?
This is someone else, Your Ladyship. There was another pending petition, someone else. Initial J, paragraph J. Apparently, the promotion of the petitioner was not considered favorably by certain sections of employees, relying on the notification dated 21/7/11 by which the department undertook the exercise of revamping restructuring. They submitted representations with an ultimatum dated 23/6/14 and demanded that the petitioner's promotion order be rectified and cancelled. Letter states that the petitioner cannot be further promoted in terms of the notification dated 21/7/11 and the rules. This letter is interesting, and this is at page 73, Your Ladyship. Page 73. 8 October 2014, and this is addressed to the President of the Association. In inviting a reference to your representation dated 1/8/14 on the subject cited above, and to say that your representation is examined and point-by-point reply is given as under. 1. Engineer Lima Wabang Iyer has not an employee of the Department of School Education. Correct, Your Ladyship. The documents amply demonstrate this fact. His name not appearing in the seniority list of professional cadre of officers does not invalidate his standing as a serving officer in the department. Also correct, Your Ladyship. 3. Any officer, unless one has come to a deputation or specifically appointed as ex-cadre, the remaining officers, whoever serving, becomes a cadre member, including those officers who are absorbed from other departments, subject to provisions contained in the department restructuring notification dated 21/7/2011 and the Nagaland School Education Service Rule 2002. Very well taken stand, Your Ladyship. 4. Annexure 5 of the department restructuring notification dated 21/7/2011, the post of additional director shall be filled by promotion of the senior most member from amongst the confirmed members of the ex-cadre from planning, health education and vocational education has not mentioned about obtaining a degree of BEd. However, the last promotional avenue of Engineer Lima Wabang Iyer will be that of additional director till such time the department restructuring notification dated Kohima the 21st July 2011 is enforced. Now, Your Leadership, in the restructuring, there was one post of additional director ex-cadre.
Yes.
One
Yes.
post of additional director ex-cadre. Now, that is also relevant because that post was filled by someone else, not by me. So I could not have been promoted to that ex-cadre additional director post because someone was already in occupation of that post. 5, 6, and 7, the department restructuring notification dated the powers was governed, contained in the department restructuring notification dated 21/7/2011 and the Nagaland School Education Service revised rules of 2002. The department seniority list of 2012 was published as the final seniority list, and based on it, officers were promoted within the provision contained under the department restructuring notification dated 21/7/2011 and the Nagaland School Education Service rules 2002. The department restructuring notification dated Kohima, the 21st July 2011 cannot be read in isolation, but should be read with the existing rules. The Nagaland putting them to the rank of additional director, subject to the condition that no further promotion from the rank of additional director as per the department restructuring notification dated 21/7/2011. So what I am aggrieved is this decision that I cannot be promoted beyond additional director because of the restructuring. The officer, in whatever capacity he is serving, is within his own rights under the authority sanction of the department. Though there is no specific notification issued to the effect that Engineer Lima Wabang Iyer has been taken into cadre post, at the same time, there is no specific provision as to how one has to be in the cadre post. The department restructuring notification dated 21/7/2011 in Annexure 6, serial number 14, Joint Director post mention about system analyst, including information and training, will come on the planning as serial number 7, and additional director post will be last promotional avenue. The government has acted based on the powers conferred by the department restructuring notification dated 21/7/2011, read with the Nagaland Service Rules, Revised Service Rules 2002, and did not in any way intend to humiliate any officer in the department. In the light of the above observations, the promotion of Engineer Lima Wabang Iyer as additional director cannot be cancelled. However, the officer concerned also cannot be further promoted thereafter. The department issued corrigendum dated 21/3/15. This corrigendum states that the petitioner would not be entitled to further promotion and that the post held by him would be restored to cadre when vacated. Page 75. Leadership. In partial modification of this department notification dated 9/7/2014, the officiating promotion of Engineer Lima Wabang Iyer from Joint Director of School Education to that of Additional Director of School Education, Vice Shri Additional Director of School Education, shall be subject to the following conditions. The officiating promotion as Additional Director will not entitle Engineer Lima Wabang to claim further promotion against any cadre post of Director, and the post of Additional Director occupied by Engineer Lima Wabang will be restored to the cadre post as and when equivalent post in the ex-cadre post becomes vacant to accommodate the incumbent. So by this notification, no further promotion, complete ban. The post which I was holding was made ex-cadre. Notwithstanding the fact, Your Leadership, that for the additional director ex-cadre post, someone was already in occupation. Then at paragraph M, page 10. The developments aforementioned was followed by the issuance of the final seniority list of officers under the department as on 1/10/15. In this seniority list, the name of the petitioner is shown as serial number 2 in the list of ex-cadre officers. Page 77 now, Your Leadership. Page 77 is the front page. And at page 78, the relevant page, I'm at serial number 2. Engineer Lima Wabang Iyer. Has Your Lordship got that?
Yes.
Engineer Lima Wabang Iyer, Additional Director. And the person immediately ahead of me, Your Leadership, Poland Tep, the one who was holding the ex-cadre.
That other
Yes,
person.
already he's also there as ex-cadre. Only by this letter, the corrigendum, and by this seniority list, I have been placed on the ex-cadre. Not earlier. And that too on the basis of, at the behest of the association. At the behest of the association. Then at paragraph N, page 11, Leadership, paragraph N. Mention to be made that though the petitioner successfully completed his period of probation, no formal orders in this regard have been issued. This anomaly was corrected through notification number dated 6/5/16 confirming his service with effect from 1/5/1992. This is also relevant to Leadership, page 79. Because all these actions contradict what the state actions did against me at the behest of the association. This is 79. 6th May 2016. On successful completion of the probation period, the Governor of Nagaland is pleased to confirm the services of Engineer Lima Wabang. If I am in an ex-cadre post, Your Leadership, can I be confirmed? Is confirmation at all necessary? Confirmation is done for persons who are appointed in accordance with the rules, not for anyone else, Your Leadership. At paragraph 4 now, Your Leadership, at page 11, that against the actions aforementioned, the petitioner submitted a representation dated 13/6/2016, requesting remedial measures. However, no action has been forthcoming from the state respondents. The representation is at page 80. No need to go into the details.
Okay.
Then at page 12, now, Your Leadership, paragraph 5. That the fact that the corrigendum dated 21/3/15 is mischievous is apparent from the records of the petitioner's service. This fact is further bolstered by the duties and responsibilities assigned to the petitioner. By notification dated 5/7/16, as an additional director, the petitioner has been appointed as State Mission Director under the Nagaland Education Business Society of Rashtriya Madhyamik Shiksha Abhiyan. Page 92. 82, Your Leadership. Page 82. In the interest of public service, the Governor of Nagaland is pleased to appoint Sri Lima Wabang Iyer as State Mission Director under the Nagaland Education Mission Society of RMSS with the following terms and conditions. The redeployment of the incumbent will be for a period of 3 years with immediate effect. The incumbent will draw his monthly salary from the office of the parent department as per his present scale of it. My parent department is a school department. Seniority of the incumbent and yearly increment, etc., will be maintained by the parent department. All service benefits are protected. TADA, etc., during the period of redeployment under the RMSA. Performer promotion, if any, as per the seniority entitlement of the incumbent, will be maintained by the parent department. On completion of the redeployment period, the incumbent will be released by the Nagaland Education Mission Society to report back for duty to the present department. My service benefits, firstly, Your Leadership, as State Mission Director, who can be appointed? Only someone who is in service, in regular service. Secondly, the order of my deployment protects my service in my parent department. Increments, promotions. After my redeployment, I will return to my parent department. Now, paragraph 6, Your Leadership. Even in the past, back to the petition, even in the past, cadre officers of the department have been appointed as Director RMSA. The RMSA is an integral component of national education policy, and the appointment of the petitioner as the State Mission Director of the said RMSA underscores the recognition by the state respondents of the petitioner's competence and ability. Therefore, it is most unjust and unfair for the state respondents to categorize the petitioner's service as ex-cadre. 7. The records would amply demonstrate that the petitioner was appointed as a regular member of the service under the Department of School Education. There can be no doubt about this, Your Leadership. The records amply demonstrate that he was appointed on regular basis in the Directorate of School Education. As a corollary thereto, the petitioner's service is governed by the Nagaland School Education Service Revised Rules 2002. In terms of the rules, the petitioner was promoted at various stages at his service career and is presently serving as an additional director. Therefore, there is no factual or legal basis for the state respondents to change his service from regular service to ex-cadre service. 8. The post of Assistant Engineer Electronics, created in the year 1988, is a regular cadre post. The Educational Technology Cell is an integral component of the Department of School Education. We will go to the rules of the designation. At various stages, the petitioner was promoted on a regular basis against regular cadre posts. All these developments in the career of the petitioner have been in terms of the rules. This is a very important point which I'm trying to make here, Your Worship. All the benefits which have accrued to him over the years has been in terms of the rules, no deviation therefrom. Therefore, it is untenable in facts and in law for the service of the petitioner as additional director to be placed in the ex-cadre category. This also, Your Worship, another person already appointed in the sole ex-cadre post of additional director, that the rules recognize the service of petitioner within this ambit. Therefore, notwithstanding the notification dated 21/7/11, the service of the petitioner is regular cadre service. In fact, even after the issuance of the said notification, the petitioner's service was treated as regular service under the rules. That is precisely the point I was trying to make, Your Worship. Confirmed in service, redeployed, his service protected. The unfortunate turn of events arose at the instance of vested interest in the department who bore animus towards the petitioner. Most shockingly, the state respondents have acceded to the demands of vested interests. At paragraph 10, that because of the categorization of the petitioner service as ex-cadre by the corrigendum dated 25/3/15, the petitioner has been superseded by his juniors. And this is a fact, Your Leadership. After 25/3/15, vacancies arose. Director never considered. He has been superseded by his juniors. Apart from being superseded, the said corrigendum places an absolute bar for consideration for further promotion. 11. Page 75, the corrigendum at page 75.
Page 75.
75. This corrigendum states that I will not be promoted beyond
Yes,
additional director,
you
and then
cannot
after I
claim.
leave, it is the ex-cadre post will become cadre post. Then the second one is notification dated 21/7/11 at page 44. I'm taking Your Leadership only to the relevant page, otherwise the notification actually starts from page 24. Starts from page 24. This is the restructuring notification, Your Leadership. Page 24. And the relevant portion is at page 44.
Serial number 14.
Yes, serial number 14, where the post of systems analyst is shown as ex-cadre. The post shall be filled by promotion of the senior most members from amongst the confirmed member of the service. Of ex-cadre of planning and vocational education. Kindly note the language also, Your Leadership. Of the service of ex-cadre of planning and vocational education, including system analyst. So, service of ex-cadre of planning and vocational, including system analyst. Because system analyst was actually never clubbed together with ex-cadre of planning and vocational before. It was a separate post altogether. And in the previous page, at page 42, at serial number 7, this is the one post of additional director ex-cadre which I was talking about, Your Leadership, in the restructuring at serial number 7. So this post, additional director selection grade, the post shall be filled by promotion of the senior most members from amongst the confirmed members of ex-cadre services planning, health service, health education, and vocational education under the school education who has rendered not less than 3 years of continuous service in the immediate lower grade of selection grade. The post of additional director of planning will be the last promotional service of the members of the ex-cadre service of school education. Your ladyship will kindly note, there is no mention of assistant analyst as far as this column is concerned. It is only in respect of ex-cadre service planning, health education, and vocational education. And this post is already occupied, was already occupied. Then the next prayer, your leadership. I'm asking that this entry at page 44, the question set aside. Yes. Then number B is direct the state respondents to rectify their seniority list as on 1/10/15, which shows the name of the petitioner as serial number 2 in the list of ex-cadre officers. This is at page 77. And the relevant page is page 78, where my name appears as serial number 2. Has your ladyship got that?
So you put in a separate seniority.
In a separate seniority list of ex-cadre officers. Thank you, John. And in terms of A1, your ladyship, I'm also asking for restoration of the previous notification by which I was granted promotion at page 71. At page 71, your ladyship. So this is the first promotion order by which I was promoted to additional director. And there was no condition that I will not be further promoted or that my promotion is against an ex-cadre post. There's my office copy. Now, if you can go to the (2002) rules, and if you can go to section 2 of the rules, the definitions at Roman 10. Regular appointment means appointment made against regular posts in accordance with the provision of these rules. So post was created, it was advertised, and I was appointed according on the basis of a selection process. Then part 2 at section 3, at rule 3. Constitution of the service. The service shall consist of the following persons, namely, persons who at the commencement of these rules are holding substantively posts specified in Schedule 1. Persons recruited to this service before the commencement of these rules. So I was appointed on 18/4/1990, your leadership, the date of my appointment.
18/4/1990.
So prior to the commencement of these rules. So persons recruited to this service before the commencement of these rules. The first one is persons who are in the commencement of these rules are holding substantively posts in Schedule 1. Second is persons recruited to this service before the commencement of these rules. 3, persons recruited to this service in accordance with the provision of these rules. So in any case, within 1, 2, and 3, I come within the ambit of the service rules. Then classification at rule 4, your leadership. The service shall consist of 2 classes of officers of the following grades, carrying scales of pay shown in Schedule 1 thereto. Next, provided the government may from time to time reduce and add any grade of post. So this is again a plenary power. The government may reduce or add posts, notwithstanding what is mentioned in the schedules, your leadership. And 2, the Nagaland School Education Service, Class 1 and Class 2, Group A, Class 1, Group B, Class 2, etc., etc. Now, Group A, leadership will see, Director of School Education, Additional Director of School Education, Joint Director of School Education, Deputy Director of School Education, District Education Officer, Senior Research Officer. At serial number 2, Roman 2, Assistant Director of School Education. B, Officer in Charge, Educational Technology Cells. Now, your leadership will recall, my post was created under the Educational Technology.
DC.
Yes, Educational Technology Cell. So the Educational Technology Cell is not alien to the rules, your leadership. The Educational Technology Cell is a service within the rules. Then at Group B also, your leadership will see Class 2 gazetted, Group B. First one was Class 1 gazetted, Group B. At serial number 3, Script Writer Education Technology Cell. So there was a cell. There was a cell in the School Education Department, which was the Educational Technology Cell. Then at Rule 5, Strength and Pay Scale. The number of posts, permanent and temporary, under each grade shall be as such as may be determined by the department from time to time. The sanctioned strength and scale of pay at the time of commencement of these rules are as shown in Schedule 1 of these rules. Now, if you may kindly turn to Schedule 1 again, your leadership. Schedule 1, which is at page 11. Very limited number of posts. Director, 1 post, your leadership. Additional Director, 1 post. Joint Director, 2. Deputy Director, 3. Senior Research Officer, 1. District Education Officer, 7. Assistant Director, 10. Principal, 9. Vice Principal, 9. DIS, 12. Vocational, 1. Headmaster, 104. Hindi Education Officer, 1, etc., etc. Limited number of posts. Only by the restructuring of 2011, a large number of posts in all categories was created, upgraded as well as created. And that is fully within the ambit of the rules. The rules allow for such creation of posts.
Restructuring was done when?
2011 in leadership. 2011. Now, Rule 6 now in leadership. Mode of recruitment. Recruitment to the service may be made by either of the following method. A, direct recruitment through the NPSC, by special selection in accordance with Rule 7, by promotion in accordance with Rule 7 and 8. Now, Rule 7. Method of recruitment. So this is primarily about recruitment after the enactment of the rules. So we're not really concerned with that here, leadership. Then B, source of recruitment. 7B, source of recruitment. 1 is direct recruitment. And 2, at page 5, departmental special selection, that is for departmental employees. Then regular promotion. She has successfully passed the departmental and professional examination and other conditions which are already in force as may be prescribed by the government from time to time before she is eligible for confirmation. So I was confirmed in year 2016 in accordance with the rules. So all along, I have been promoted by DPC. My service has also been confirmed in terms of Rule 15. Then 17 is seniority leadership. Seniority in service shall be determined in accordance with the principles as laid down by the government from time to time, and different grades on the basis of which seniority will be fixed. Then we can turn to the schedule now, leadership, Schedule 2. Firstly, if you can turn to page 14. Page 14. At entry 8 of Schedule 2. Has the leadership got it? Entry 8.
Schedule 2.
Entry 18. Entry 18 at page 11.
Officer in charge.
Yes. Officer in charge.
This cell.
Yes. Once in the column of eligibility leadership,
Mm.
once the present incumbent officers holding ex-cadre posts are promoted or retired, the posts vacated by them shall cease to be ex-cadre posts. Subsequent filling of each of such posts shall be regulated as per the provision contained in the rules, procedure. Promotion, if any, shall be made on the recommendation of the committee. Promotion shall be made on the recommendation of the committee. So this is ex-cadre. Now, this is officer in charge of the ET cell. That was in the grade of assistant director. Now, leadership, the schedule 2 at page 4 now. At page 12, at entry 4. We are concerned with
Page.
page 12. Page 12. Page 12, entry 4. Deputy director, that is the next promotional post. That is the next promotional post. The post of deputy director should be filled up by promotion on the recommendation of the committee from among the confirmed officers, provided that the officer has completed a qualifying service of 18 years in the school education department on the first day of January of that year, of which at least 3 years should be in the grade of assistant director. Then, joint director. The post of joint director shall be filled by promotion on the recommendation of the DPC. Selection should be made from among the confirmed officers, provided that he has completed a qualifying service of 20 years in the school education department, and at least 3 years should be in the grade of deputy director. The next one is additional director elevation. The post of additional director shall ordinarily be filled by promotion on the recommendation of the committee. Selection shall be made from among the confirmed officers, provided that he has completed qualifying service of 25 years in the school education department as joint director. Then director elevation. The post of director shall ordinarily be filled by promotion on the recommendation of the committee. Selection shall be made from amongst the confirmed officers, provided that he has completed a qualifying service of 23 years in the school education department and at least 2 years as the additional director. So in terms of the rules of 2002, there was no bar for the petitioner to be considered for promotion to the post of director. Or even in terms of the restructuring. Because in terms of restructuring, more posts of director were created eventually. Not just additional directors, etc., but more posts of directors were also created. So there was no bar for the petitioner to be promoted to above the post of additional director, even in terms of the rules of 2002. Now, during the pendency of this petition, the rules of 2017 came into force now. We have an extra copy. Leadership is the 2017 rules available on file.
Was it supplied? Earlier?
Yes, yes, Your Leadership, it was. 2017 service rules. We have a copy, extra copy of 2017 rules.
Can you just check?
Can you apply that for the time being? The blue cover
2017 rules.
for the time being.
Ito na, ini separate ko di. Sabi, dahil ni Bob na.
Can you show us another copy?
2002, so sorry. It is. It's not there.
So, Your Leadership, the internal page to the straight away the first page, Your Leadership, 29 November 2017. In exercise of the powers conferred by the provision to Article 309 of the Constitution of India, the Governor of Nagaland is pleased to make the following ruling. They shall come into force from the date of their publication in the official gazette. So, official gazette is dated 29/11/2017. This is a copy of the gazette publication itself, Your Leadership. 29/11/2017. Now, Your Leadership, if you may go to Rule 3 at page 3. Constitution of the service. The service shall consist of the following persons. 1. Persons who at the commencement of these rules are holding regular appointment to the posts specified in Schedule 1. If you may go to Schedule 1, Your Leadership. At page 22. So, one post of principal director, has the leadership got that? Serial number 1. Then secondary and elementary, they are in the secondary and elementary, there is one director, there is one additional director, 3 joint directors, etc., etc. Then in the higher secondary, in the next page, your leadership at page 23, there is one director, one additional director, and so on and so forth. Then at serial number 3, below your leadership, additional director for planning, physical education, Hindi, and language. So even the earlier ex-cadre post, the planning, physical education, Hindi language, this was categorized as, if your leadership will recall, as the ex-cadre category. This has been brought within the ambit of the rules. And there is an additional director. There is an additional director now. Then serial number 4 also your leadership will see. Serial number 4 also your leadership. Joint director for planning, physical education in Hindi. More posts brought under the cadre of the service. 5 physical education. Then 6 your leadership will see. Planning. Planning also brought within the ambit of the service rules. 7 language, 8 Hindi. All these have been brought within the ambit of the rules. And page 27. Now, this is most interesting, where the picture takes a completely different turn altogether. There is a specific cadre of service called the ex-cadre. And this is at serial number 14. Has the leadership got that? Ex-cadre. And who are in these ex-cadre posts? Joint Director, Health Education, HE. Assistant Engineer, Program Scriptwriter, Program Officer, Assistant Program Officer, Evaluation Officer, Special Officer, Training Officer, Legal Assistant. Even the Legal Assistant is an ex-cadre officer. So these, according to 2017 rules, which came into effect from 29/11/2017, these are the only posts which are now ex-cadre. So therefore, can my service be categorized as ex-cadre now, Your Leadership? In terms of the rules of 2017? Can it, even in terms of the rules of 2002, it was not ex-cadre. Now, in terms of the rules of 2017, the state themselves has confirmed that my service is not ex-cadre. And the only ex-cadre officers insofar as the Director of School Education is concerned is those who are mentioned in serial number 14 of Schedule 1. Then, Your Leadership, Schedule 2 is the channel of promotion. I am now in the grade of Additional Director, Your Leadership. The post of Additional Director shall ordinarily be filled by promotion on the recommendation of the committee. Selection shall be made from among the confirmed officers, provided that he has completed at least 2 years as Joint Director/DEO. This is, I'm already there, Your Leadership. Then Director. The post of Director shall ordinarily be filled by promotion on the recommendation of the committee. Selection should be made from amongst the confirmed officers, provided that he has completed at least 1 year as additional director. That is all that is required. Must have completed at least 1 year as additional director. That is the only criteria that is required. So I was promoted. Page 71 in leadership. I was promoted as additional director on 9/6/2014 at page 71.
Nine, six,
2014. So by 9/6/2015, I was eligible for promotion to director. 1 year in leadership, according to the schedule. 9/6/2015, I was eligible to be considered for promotion to the post of additional director. But because of the corrigendum, at the behest of an association, that promotional avenue was denied to me. That is my case in a nutshell, in leadership. That is my case. And that denial was in violation of the rules, both the 2002 rules as well as the 2017 rule. Now, your leadership, the state has filed its affidavit. The first affidavit was filed on 24/7/2019.
There are many affidavits here also.
Yes, Your Lordship, but the one which was filed on 24/7/2017
Yes.
by respondents 1, 2, and 3. And this was filed by the Secretary of the Department. We can go to paragraph 3 straight away at page 2. Page 2, paragraph 3. A. The service conditions of the officers serving in the School Education Department, Nagaland, is governed by the Nagaland School Education Service Revised Rules 2002. Whereas the classification of service, sanction strength, and scale of pay is provided in Schedule 1, the method of recruitment is provided in Rule 7, read with Schedule 2 of the service rules. In a sanction strength and scale of pay of posts under the School Education Department, the post of Assistant Engineer, ET Cell, Executive Engineer System Analyst is not included in the service rules. Therefore, it cannot be said that the petitioner belonged to regular cadre and that his service condition is governed by the Nagaland School Education Service Rules of 2002. So this is the first ground that they are taking here, issue. That my service is not specifically named in the rules of 2002. But what the state very conveniently ignores is that the post was created in 1988 and based on a specifically for the Department of School Education before the rules came into force.
Post was created in 1988.
And through a selection process, I was appointed in 1990. And the rules of 2002 state very clearly, in addition, at Rule 3. At Rule 3. Persons where the commencement of these rules are holding substantially posts specified in Schedule 1. 2. Persons recruited to the service before the commencement of these rules. So the fact that my post is not specifically mentioned apart from the ET cell. ET cell is there, your leadership. There's no doubt about that in the rules of 2002. Educational Technology Cell is there. It is not my fault. It is a fault on the part of the state. However, Clause 2 of Rule 3 specifically protects my service. And the state respondents are ignoring this. Then,
Yes.
At B, by notification dated 18/4/90, the petitioner was appointed as assistant engineer in ET cell under the Directorate of School Education. So this is an admission of sorts, Your Ladyship. This is an admission that he was appointed as assistant engineer, ET cell under the Directorate of School Education. There cannot be a better admission than this, Your Ladyship. Subsequently, by notification dated 24/10/2003, the said post of assistant engineer held by the petitioner was upgraded to that of executive engineer and designated as assistant analyst. Therefore, thereafter, the post of assistant analyst held by the petitioner was again upgraded to the rank of joint director. As earlier stated, the post of assistant engineer, executive engineer, system analyst is not included as one of the regular cadre posts in the service rules. Now, if you may pause here for a moment, Your Ladyship, if you may pause here for a moment, is not included in the cadre post of the service rules. In the year 2011, a large number of posts were created, not contemplated in terms of Schedule 1 of the rules in 2002. Will the state now apply the same argument and declare all those posts as ex-cadre? From one post of director, we now have 3 posts of director. From one post of additional directors, we have 3 posts of additional directors. We have a large number of joint directors. We have a large number of district education officers. All these posts are not contemplated in Schedule 1, Your Ladyship. The nomenclature may be the same, but these posts are not contemplated in Schedule 1. If we apply the same yardstick, would the state concede or would the state agree to have all these posts declared as ex-cadre? That would be an impossibility, Your Ladyship. And that would also be stretching the argument a little to the other side. But this is the nature of the argument that is being advanced against me by the state. And that also at the behest of the association. And notwithstanding the reply, which was a right reply, which we went through in detail in addition. When the state replied to the affidavit of the representation of the association. Yes, yes. The only adverse circumstance in that letter was that, as insofar as my case was concerned, is that I will not be promoted thereafter, and my post will be ex-cadre and will revert back to cadre. Otherwise, the arguments for rebutting the claims of the association, those are perfectly legal, Your Ladyship, perfectly tenable. Then, Your Ladyship.
Just take.
Very well, Your Ladyship. So your leadership,
Yeah.
the reply was perfect, except for a portion where it restricts my service.
Yes.
Then coming back to page 3. Where the respondent say that is not included as
Included.
one of the regular posts in the service rules. Therefore, his promotion in the post of EE system analyst was not by way of regular promotion as envisaged by the service rules, but by way of gradation. Now, look at the falsehood in this statement here, Your Leadership. Look at the falsehood in this, not by way of regular promotion as envisaged by under the services by way of gradation. It was regularized by the DPC. My promotion was regularized by the DPC. How can the state, by this affidavit, make such a false statement, Your Leadership? The department never treated the petitioner as one of the members in the service of the school education. More false statements, Your Leadership. The records amply demonstrate the falsity of these statements. The petitioner also accepted the said position since his initial appointment and therefore never questioned the validity and legality of the service rules, nor did the petitioner challenge the non-inclusion of his post in the service rules. Was it necessary, Your Leadership? It was never necessary. All along, I had been given the benefit of the rules. All along, I had been promoted in accordance with the rules. When I was deployed, there also my service was protected, Your Leadership. Was there any necessity for me to challenge the service rules when I was given the full benefits of the rules? Let's see that in the school education department, there are several wings such as planning and vocational education, health education, etc. The officers appointed to such wings are not treated as regular cadre member of the service under the school education department. Now, again, Your Leadership will see, this is also a false statement. Those who are serving in the health, in the planning and vocational education cadre, their services were also regularized by the DPC in the earlier minutes of the DPC.
And now they have come under the rules.
And now they have come under the rules of 2017. Then E, by notification dated 21/7/11, the state respondents has revamped, restructured, and streamlined the school education department, directorates, subdivision, and circle levels. Paragraph 7 of the said notification provided is under the mode of recruitment to the administrative cadre of the Department of School Education, including procedure and promotion of graduate teachers under the department is described in Annexure 6. And new service rules will be brought out in due course, incorporating these changes and procedures for appointments and promotions. Now, an interesting point of note here, Your Leadership. Posts are created, well and good. Well and good. It is well within the powers of the state to create posts. But if there are rules enforced regarding how promotions are to be made, the rules have to be followed. Rules have to be followed. So there are two parts to this restructuring of 2011. The only good part, if I may say so, Your Leadership, is the restructuring and the creation of posts. The rules of 2002 are still subsisting. So any promotion to the posts created must be in accordance with the rules of 2002 and not in terms of this in Annexure 6. Now, if you can turn to Annexure 6, which is at page 41. Page 41, Annexure 6 of my writ petition, Your Leadership.
Yes.
Mode of appointment and promotion under the Department of School Education, Nagaland, as on 1/8/2011. Principal Director, promotion is 100%. The post shall be filled by Secretary of Department on ex officio capacity as an IAS officer. And 2, Director, the post shall be filled by promotion of the senior most members from amongst the confirmed member of the service of the higher secondary education who has rendered not less than 2 years of continuous service in the immediate lower grade. This part is all right, leadership. Director higher selection grade, The post shall be filled by promotion from the senior-most members from amongst the confirmed members of the school education, including communitization, who has rendered not less than 2 years of continuous service. Additional director, the post shall be filled by promotion of the senior-most members from amongst the confirmed members of the service of the higher secondary education, who has rendered not less than 3 years of continuous service in a grade, lower grade, selection grade. 5, the post shall be filled by promotion of the senior-most members from amongst the confirmed members of the service of the secondary education, who has rendered not less than 3 years of continuous service in the immediate lower grade of selection grade. 6, additional director. The post shall be filled from amongst of the senior-most members from amongst the confirmed members of the service of the elementary education, including communitization, who has rendered not less than 3 years of continuous service in the grade, lower grade of selection grade. 7, additional director, selection grade. The post shall be filled from promotion by promotion from amongst members from amongst the confirmed members of the ex-cadre service of planning, health, education, and vocational education under the school education, who has rendered not less than 3 years of continuous service in the immediate lower selection grade. The post of additional director planning will be the last promotional service for the members of the ex-cadre service of school education. So against this post, someone was already there in addition. Someone was already there. Then next one, joint director in leadership. The post shall be filled by promotion from amongst the senior members from amongst the confirmed members of the service of higher secondary education, who has rendered not less than 5 years of continuous service, etc., etc. 9, joint director. The post shall be filled from the secondary education. Then 10, from the elementary education. Then 11, from the elementary education. Then 12, elementary education. Then 13, adult education and distance education. Then 14, joint director. System analyst, the post shall be filled by promotion of the senior-most members from amongst the confirmed members of the service of ex-cadre of planning and vocational education service system analyst. So even at that point of time, your leadership will remember there was already someone who was appointed as ex-cadre along with me, including system analyst who has rendered not less than 5 years of continuous service in the immediate lower selection grade. So in this, even at this certain point of time, after the restructuring, someone was already holding the ex-cadre post. Someone was already holding the ex-cadre post.
If you see this additional director list,
Yes, your
so
leadership.
one is to be from higher secondary,
Yes.
one is from secondary,
Yes.
one is from elementary,
Yes.
and one is from this
The ex-cadre.
planning, health
Yes.
education, etc.
Yes.
Then in that case, isn't there some conflict? Like how could you have been appointed? Because you are neither from higher education nor secondary nor elementary.
No, I am from secondary education cadre leadership. I am from secondary education cadre. I am from secondary, but not the teaching side, but I am from the secondary education cadre. Your leadership will see my qualification is very different. I am not in the teaching line. I am not in the planning and health education vocation line also. Education technology cell. Educational technology scale under the school education department. So I was in the secondary education line.
Otherwise, secondary education would be, higher secondary education would be class
Higher secondary is 10+2.
10+2
Yes. Yes.
principals,
Wow. Yes,
etc.
yes.
And
Secondary
secondary
is
education
10.
would be the schools
Yes.
plus 10.
And your leadership will recall, I was also the director of the RMSA. So I was under the school education department.
Okay.
Then so continuing with page number 4, it is pertinent to mention herein that a new rule is yet to be brought out incorporating the proposed changes and procedure for appointments and promotions. Excuse me. Now, during the pendency, your leadership, 2017 rules have come into force. And the 2017 rules do not discriminate against me, your leadership. The school education, the rules of 2017 do not discriminate against me. That's paragraph D. Pursuant to the notification dated 21/7/11, the post held by the petitioner was upgraded to the post of joint director and thereafter the post of additional director. So now again, your leadership, a picture is sought to be painted as if only my post was upgraded to joint director and additional director. Not true, your leadership. Many posts were upgraded to joint director, many posts were upgraded to additional director. Therefore, vested rights, if any, acquired by the petitioner has to be traced to the notification dated 21/7/2011. The petitioner being in the rank of additional director, his next promotion is to the rank of director. An indirect admission, his next promotion is to the rank of director. There are two posts of director in the school education department, and the notification dated 21/7/11 clearly provides that a post of director should be filled inter alia by promotion of the senior members from among the confirmed members of service of higher secondary and school education. The petitioner is neither a confirmed member of the service. This is again a wrong statement now, your leadership. The petitioner is neither a confirmed service of the higher secondary education nor of school education, elementary education. As such, the petitioner has no right to claim further promotion. Now again, if you may go back to the order of confirmation, your leadership. Page.
That was speech.
Page number. Confirmation. Confirmation. Okay. Information of service. So, at page 79, your leadership.
79, yes.
This is dated 6th May 2016. This is issued by the Department of School Education. On successful completion of the probation period, the Governor of Nagaland is pleased to confirm the service of Engineer Lima Wabang Iyer to the post of Assistant Engineer in the scale P of such and such. Commissioner Secretary to Government of Nagaland, Department of School Education. And your leadership will see the endorsement to at number 1, the Director of School Education. So this is also again another false statement, your leadership. Just to deprive me of my just benefits. Another false statement. Then page 5. Moreover, as per the service rules, there is only one post of director and also one post of additional director in the school education department. Now, this is important, your leadership. One post of director and one post of additional director in the school education department. But by notification dated 21/7/11, the post of director and additional director are increased to 2 and 4 respectively. Out of the 4 posts of additional director and issue 6 to the notification, it provides inter alia that one post shall be filled by promotion of the senior most members from amongst the confirmed member of the ex-cadre services of planning, health and education and vocational education. It further provides that the post of additional director planning will be the last promotional avenue for members of the ex-cadre service of school education. Now, this no. Leadership, this is not very clear, but this document itself again shows the kind of false statements the state is making just to deprive me of my benefits. So this is a notification which is type copy is at page. There's a type copy of the original leadership. This is a notification dated October 2012. The Governor of Nagaland is pleased to promote the following joint director, ex-cadre. Kindly note, your leadership. And Deputy Director, ex-cadre class 1 gazetted of School Education Department, against the resultant vacant post of additional director, ex-cadre, and joint director, ex-cadre class 1 gazetted, mentioned against each under the establishment of the Directorate of School Education Nagaland on an official basis in the KP of such and such. Now, this is 2012. This is after the restructuring. Now, look at the person at serial number 1 in leadership. She Poland Tep, joint director, additional director, already holding the post, one post of ex-cadre. Then already there. Then next page, Your Leadership, at page, this is a notification dated 12 December 2007. This is one person who was brought in to the ex-cadre post of health education, 2007. He is a doctor, Your Leadership, health education, 2007. Then 2011, the deputation service of this person was absorbed in the health education service, the ex-cadre service, as joint director. Then 2009. Has the leadership got that? This is 3rd December 2018. Yes, this is one Metsutosu Reza, joint director, promoted to additional director, and against the ex-cadre post, the so-called ex-cadre post. But 2019, he becomes common cadre for planning physical education. Now within the rules. Within the rules. Next person also, Shri Tim Jennington, Deputy Director Planning, Joint Director, all within the rules. So even the statements at page 5, false statements, Your Leadership. Then what does the state respondent say after making such false statements? Your Leadership, in the next paragraph, having accepted the enjoyed the benefit of the said notification dated 21/7/11 by way of upgradation of issuing promotion from the post of joint director to that of additional director, the petitioner has no right to question the validity and legality of the said notification dated 21/7/11. The petitioner is stopped by his conduct from challenging the said notification dated 21/7/2011 by application of the principle of acquiescence and waiver. Now again, this is the most unfortunate statement in Your Leadership. Yes, I was given the benefits of the restructuring of 2011, but I was promoted to a regular post. Others were promoted to these two posts. Others were promoted to these posts. And this is the most unfortunate statement, most unfortunate manner of doing things by the state respondents in Asia, just to deprive me of my benefits. Then the others, Your Leadership, are replies to my statements. Now, when the matter was heard, Your Leadership, at that point of time, this Honorable Court wanted to know whether my promotion was in terms of the 2011 notification or in terms of the rules of 2002. So the state was asked to file another affidavit, and that affidavit is dated 12/11/2018. Now, my Lord, Your Leadership will keep in mind that insofar as the ex-cadre posts are concerned, they already filled. They already filled. And I was promoted to a post of the common cadre. Now, this is the affidavit of the state, the additional affidavit which was filed by the state. This is filed on 12/11. Yes.
2018.
Yes. And page 2. The post of Assistant Engineer Electronics, Class 1 gazetted, which was upgraded to the post of Executive Engineer and designated Assistant Analyst, is not included as one of the regular cadre posts in the Nagaland School Education Service Rules of 2002, but the pay scale structure is equivalent to that of Deputy Director, an indirect admission. But again, a wrong statement, Your Leadership. It is not included in the Service Rules of 2002. That is a totally wrong statement. Therefore, basing on the pay scale structure, the petitioner has been shown to be a Deputy Director in the notification dated 2/9/2011. The petitioner was never appointed as a Deputy Director before his officiating promotion to Joint Director by notification dated 2/9/11. Is this an acceptable statement, Your Leadership? Can the state, by its affidavit, discount its own actions, Your Leadership? Is that a valid proposition of law? It may also be mentioned herein that the post of Executive Engineer System Analyst was never converted to Deputy Director. Look at this, Your Leadership. They themselves upgraded And they are now saying it was never converted to deputy director. And C, that as the post of EE, system analyst, is not included as one of the regular cadre posts in the service rules of 2002. The officiating promotion of the petitioner to the post of joint director by notification dated 2911 was not made from the feeder post of director. A wrong statement, Your Lordship. The petitioner was upgraded, the post held by him was upgraded in terms of the notification of 2011. They wish to undo their own actions. They wish to backtrack and wish, it is their wish that I was not there in the service in the first place, Your Lordship. Apparently, the official promotion was by way of upgradation as reflected in a notification dated 2911. The upgradation was done pursuant to the notification dated 21/7/11 and not as per the Nagaland Education Service 2002. Look at this, Your Lordship. A large number of posts upgraded as permitted by the rules of 2002. And now they are saying my post alone was not upgraded in terms of the rules of 2002. My post alone. A classic case of hostile discrimination in leadership. Hostile discrimination by the state in collusion with the association. D, the upgraded post of EE Class 1 Gazetted, which was redesignated as system analyst by notification dated 24/10/2003, is not included as one of the regular cadre posts in the Nagaland School Education Service Rules 2002. Therefore, as per the Nagaland School Education Service 2002, the post of EE system analyst is not equivalent to the post of director, deputy director in school education. Here in one post, they say it has been shown to be deputy director. In next statement, they say it is not deputy director. This is what the petitioner is dealing with in the department. This is what the petitioner had to deal with in the department. Unfortunately, he's not anymore. He's not here anymore, Your Lordship. He passed.
Oh.
He passed. And so he was substituted by his wife as his legal heir. That is the case of the state responsibility. The association has filed, Your Lordship, a very voluminous affidavit in opposition. It was filed on 15/6/17. At page 2. Page 2, paragraph 2, in addition. The petitioner was initially appointed as assistant engineer class 1 gazetted in the school education department. So they also admit he was appointed in school education department. In fact, they cannot deny this. The post is a technical post. His service has been utilized for technical works. No doubt about that, Your Lordship. I am on the technical side, but in the school education department. The members of the private respondent number 4 initially joined their services as teachers in the school education department, who are presently working as administrative officers in various grades in school education department. C, the school education department maintains seniority list of all the non-technical staff teaching cadre as per Rule 17 of the Nagaland School Education Service Rules 2002. However, there is no seniority list for the technical staff, as the petitioner was the lone staff initially appointed as assistant engineer in 1990 and subsequently upgraded to the post of EE in 2003. The name of the petitioner was never appeared in the seniority list of the teaching staff, non-technical, during 1990-2011 because the petitioner was appointed against the post as assistant engineer electronics in the year 1990. This is, my name does not have to appear in the list of non-teaching staffs. In addition, my name appears in the seniority list of officers in the directorate. My name will appear in the seniority list of administrative officers in the directorate, not in the seniority list of the teaching staff. Now, under the Directorate of School Education, the department maintains two separate seniority lists. So, elementary and school education, officers of the higher secondary education. Thus, F, the promotion channels for teaching cadre are being followed as the seniority position in the seniority list at different stages of their service career to be considered for their promotion to the next post. Since the post held by the petitioner is a technical post, he could not jump to the promotional channel of the teaching cadres at any level. This is their case. I cannot jump into the promotion channel of the teaching cadres at any level. But, Your Leadership, now, in the rules of 2002 also, in the rules of 2002, kindly see, Your Leadership, the Schedule 1. Schedule 1. Has the leadership got that? Schedule 1. All the way in the list of the name of the posts. And you come to serial number 17, is training officer. After that, 18, assistant headmaster. Now, assistant headmaster is is a class 1 gazetted post. Leadership. Assistant headmaster is a class 1 gazetted post. Then Hindi instructor, we're not considered that. Language officer, we're not considered. Postgraduate teacher. Postgraduate teacher. Vocational teacher, assistant research officer. So graduate teacher is not a post contemplated in the rules of 2002. And if your leadership will come to rule 4, classification of posts at page 2. Group A is class 1 gazetted, and Roman 1 is the higher echelons of the department, up to F, the senior research officer, and Roman 2 is assistant director of school education, officer in charge, ETSL, etc., etc. So I am in 2 at the time of entry. At the time of entry. Assistant director. Now, 3 is deputy inspector of the schools, headmasters of government high schools, Hindi education officer, etc., etc., etc. No graduate teachers here. Then B, assistant headmaster, is class 2 gazetted, your leadership. Class 2 gazetted. Class 2 gazetted. Language officer, script writer, subject teachers, vocation teachers, assistant research officer. So apparently, your leadership, those who form this association, some of them may be in class 2, assistant headmaster, maybe. No details are available. We don't know, your leadership. Some of them. Oh, they may not even be there. Not even one of them may be there. And apparently, the representations submitted was by the All Nagaland School Teachers Association, graduate teachers. And the name of the association is also the Nagaland School Education Administrative Officers Association. But the representation your leadership will see is ANSTA, All Nagaland School Teachers Association. So who are the administrative officers, basically, your leadership? Who are the administrative officers? Whose services I have adversely affected? And in what manner have I affected the services? Were any of them, your leadership, were any of them entitled to be promoted to additional director? The post which I was holding. Were any of them in a zone of consideration for promotion to director, since I was holding a post of additional director. If I am holding the post of additional director in violation of the rules, someone in the feeder grade of joint director is an aggrieved person. Your leadership, someone in the feeder post of joint director is an aggrieved person. And that also at that relevant point of time when I was promoted. Does the association name even a single person whose promotional avenues I denied it? Not even a single person. It is just an association which says that my entry into service affects their promotional avenues. So therefore, the manner by which the association presents itself, by their own arguments, they are not an aggrieved person. That is the point I'm trying to make. They are not an aggrieved person. And therefore, their affidavit, much has been said in their affidavit, but my stand is this: the association is not an aggrieved person, and it cannot question my service in the Directorate of School Education. Also, Your Leadership, on the basis of representations submitted by this association and other sister associations, the state respondents could not have issued the corrigendum placing my service as ex-cadre and put me in the list in the seniority list as an ex-cadre officer. That also, Your Leadership, in violation of the rules of 2002 and in violation of the rules of 2017. So that is, insofar as the affidavit of the respondent, the private respondent is concerned. Then, Your Leadership, may kindly see, come to paragraph J. Paragraph J.
J of the respondent.
Yes, yes.
Yes.
The government, by notification dated 21/7/11, has come out with a revamping and restructuring policy to produce quality and value education to implement various programs under the department. Under the new policy, the director has created the following posts: Principal Director 1, Directors 2, Additional Directors 4, Joint Directors 8. Whereas, as per the Nagaland School Education Service Rules 2002, the director is the head of the department. Now, a very interesting statement here, Your Leadership. Though they also indirectly wish to say that in terms of the service rule, there's only director. But by the restructuring, so many other posts were created. And based on the restructuring policy, the post of system analyst was included under the planning and was declared as ex-cadre post. It was not included it was not included in the planning, Your Leadership. A whole number of posts were clubbed together. Then, and the petitioner was aware of such modification made on the basis of the restructuring policy of 2011. Petitioner's post comes under system analyst as per the restructuring policy of 2011. Thereafter, in 2011, by a common promotion order dated 2/9/11, the petitioner was promoted, upgraded to post of joint director, which was a post created as per the restructuring policy. After accepting all the conditions of promotion order, the petitioner cannot turn around and challenge the restructuring policy. A wrong statement here, Your Leadership. I am not challenging the restructuring policy. I'm not challenging the restructuring policy. In terms of the restructuring policy, I was promoted to joint director. Someone else was promoted to the ex-cadre post. And in spite of knowing fully well that someone else was appointed to that ex-cadre post, the states are turning around. The state is now turning around at the behest of the union and saying that I was promoted according to that ex-cadre post. That is why I have to now come before this honorable court and challenge that designation. That is my case. That is my point, Your Leadership. So the union is saying I accepted benefits under the restructuring policy, and I cannot turn around and question the same. But that is not a correct statement. In terms of the restructuring policy, I was promoted, but to a different post, not to the ex-cadre post contemplated by the 2011 post. just to cover all bases, your leadership, the now frequently asked, raised argument that the basic order has not been challenged. That is why I am resorting to this exercise. But the records are very clear. I was promoted to a post under the common cadre. Someone else was promoted to the ex-cadre post. Then, your leadership, paragraph L. However, the post of EE held by the petitioner had been shown as deputy director and upgraded that post to the rank of joint director by notification date 2911. This was done by the state respondents to show undue favor to the petitioner to enable him to come to the promotion channel of the officers of the teaching staff, non-technical. So this is what they are saying now, your leadership. Who are the members of the association? Officers of the teaching staff. Officers of the teaching staff. So where is the locus standi for them to challenge? Firstly, my appointment as assistant director, whether they like it or not, is assistant director, deputy director, joint director, now additional director. What locus standi do they have in leadership? They are teachers. They first have to progress to an assistant headmaster, then to headmaster, then further up the chain to assistant director. Not before. Then the other interesting ground they have taken at paragraph M, your leadership, that after the order of post upgradation from assistant engineer to executive engineer, there was no official order by which the post of EE has been redesignated as deputy director. Is it necessary, your leadership? As a matter of fact, the post of deputy director is a non-technical post. Therefore, the post of the petitioner as executive engineer cannot be converted as deputy director. Is it justified for the association to come out with such a statement, your leadership? The state is the ultimate authority. The state has chosen to treat my service as assistant director, deputy director, promote me to joint director, and additional director. Who are they, the association, to say or to insist or to demand that my upgradation to the post of deputy director must be followed by an order redesignating my service, the nomenclature of my service? Then N, under the restructuring policy of 2011, the ex-cadre officers cannot go beyond additional director. The petitioner got promotion to the post of joint director and additional director based on the restructuring policy. Therefore, the last promotion revenue of the petitioner as per the restructuring policy will be that of additional director, and thus he cannot claim further promotion. An absolutely false statement here also, again. I was given the benefits of the restructuring policy like all others in the common cadre. In the ex-cadre post, someone else was promoted, both in the grade of joint director as well as additional director. And even otherwise now, your leadership, with the rules of 2017, this argument holds no water. 14. Then at K, paragraph K, your leadership, based on the restructuring policy of 2011, the post of system analyst was included under the planning and was declared as ex-cadre post, and therefore the petitioner was aware of such modification made on the basis of the restructuring policy of 2011. Petitioner's post comes under system analyst as per the restructuring policy of 2011. Thereafter, in 2011, by a common promotion order dated 2/9/2011, the petitioner was promoted, upgraded to the post of joint director, which was a post created as per the restructuring policy. After accepting all the conditions of promotion, the petitioner cannot turn around and challenge the restructuring policy of 2011. So again, the picture that is attempted to be conveyed, your leadership, is that there was only one post of joint director which was upgraded. There were a large number of the posts of joint directors which are upgraded, not just my post, including the ex-cadre joint director post where someone was appointed, and I was appointed in the common cadre. And L, However, the post of EE held by the petitioner had been shown as director and upgraded that post to the rank of joint director by notification dated 2911. This was done, etc., to show undue favor. Then M is the one which says that there was no official order redesignating the post of EE to deputy director. Then N, under the restructuring policy, cannot go beyond additional director. Then O, from the promotional channel of ex-cadre, Shri Polam Tep is senior to the petitioner in the rank of additional director who appears as serial number 1 as per the senior list of ex-cadre as on 1/10/2015. And the petitioner's name appears as serial number 2 in the set list. There is only one post of additional director in the category of ex-cadre, which is presently held by Shri Polam Tep. This is precisely the point I was making, Your Ladyship. The ex-cadre post of additional director was already occupied. And Your Ladyship, the documents which I furnished, the post of joint director was also already occupied. Is presently held by Shri Polam Tep, and therefore the petitioner can claim for promotion to the post of additional director as and only when Shri Polam Tep retires, and to that effect, the respondent number 4 has no objection. An absolutely false statement here, Your Ladyship. A misconceived statement. One post of additional director, one post of joint director, ex-cadre, both occupied. I was promoted into common cadre under the restructuring policy. More than one post of joint director, more than one post of additional director. Misconceived on the part of the association to make such a statement, Your Ladyship. And not only misconceived, very unreasonable on the part of the association to say that I can only be considered against these two posts and not any other posts. Then P, as per the restructuring policy, there are 5 different promotion channels, etc., etc. Then Q, if the petitioner is allowed to come to the promotion channel of the graduate teacher or postgraduate teacher. Again, this is where this makes out who the association is representing, Your Ladyship. If the petitioner is allowed to come to the promotional channel of graduate teacher or postgraduate teacher and hold the post of additional director, it would affect the promotional avenues for the other officers who are before this honorable. So promotional channel of graduate teacher or postgraduate teacher, they are way down below assistant director, Your Ladyship. Way down below assistant director. So where is the Locus standi for the association to be espousing the cause of graduate teachers and postgraduate teachers? Apart from espousing the cause, Your Ladyship, the point I made earlier, the association is not an aggrieved person. That is the primary point, Your Ladyship. The association is not an aggrieved person. Then, at paragraph R, however, to the utter surprise of the members of the private respondent number 4, the post held by the petitioner has been shown as deputy director while giving officiating promotion to the writ petitioner to the post of joint director by upgradation. Now, this statement, Your Ladyship, detracts from their own statement that the post has never been redesignated. Not necessary. When the government itself shows that the post held by me is deputy director, where is the necessity to redesignate? And it is up to the wisdom of the government to decide. It is fully within the prerogative of the government to decide the nomenclature, the status of posts. Who is the association to insist that it should be done in the manner that they choose? This was illegally done. Now, what they say now is this was illegally done by the state respondents to show undue favor. So, in one hand, they say it was not done. Now they say it was done. And then they say it was illegally done to show undue favor. Then, next page at paragraph S. The notification dated 2/9/11 by which the petitioner was given promotion to the post of joint director by way of upgradation had been done in terms of the restructuring policy of the Department of School Education. Yes. D. Promotion. Clause 2 and 3 of the promotion notification to 2/9/11 reads as follows. The officiating promotion is made against the post creation upgradation under the restructuring by notification dated 21/7/2011. The officiating promotion is issued on the condition that the officer obtained via degree within 3 years as an exception case. The writ petitioner has accepted the upgradation order dated 2/9/11, which was issued pursuant to the restructuring of the department by notification 21/7/11. The same notification had clearly provides that the service of ex-cadre includes planning and vocationals, including system analysts. The present petitioner has already accepted his promotion under the order dated 2/9/11, which was issued in terms of the restructuring policy. Now, here, Your Ladyship, The fallacy in these statements, and the ground taken in these statements, is the association is under the assumption that I was promoted against the joint director post created for the ex-cadre wing. And that is a wrong presumption. The records amply demonstrate that someone else was appointed to that ex-cadre post. And I was promoted in the common cadre. Then paragraph X at the bottom of the page. In short, the present petitioner cannot be given promotion as joint director and additional director who are non-technical posts. However, with the restructuring policy of 2011, the government is kind enough to allow the officers from the ex-cadre to reach the level of additional director through a separate promotional channel. That as per the latest seniority list of the Education Department, both elementary and school education, higher secondary education, the petitioner's name is not included, but his name is included in the ex-cadre list of serial number 2 in the seniority list of 2015 and 2017. Due to the uncalled promotion of the petitioner and his claim for promotion in the teaching category line of promotion is illegal for he being appointed as technical person by the illegal acquirement of the post of the additional director in the administrative setup of the department, the promotion of the senior most officers, namely Srimati Sentimenla, who appears at serial number 1 in the seniority list of 2017, and one Shri Wontungo Tsopo, who are also the members of the association and whose name appears in both the seniority list of the education department, are at stake and are not given promotion, and therefore the rights for promotion are deprived. In fact, your leadership, since no promotion was given to me, this person, Wontungo Tsopo, he is now the present director, someone who is much junior, And Z, if the petitioner being appointed as a technical person, assistant engineer, cell is allowed further promotion in the administrative setup. Now, your leadership, there is no dispute that I am not from the teaching line. I am in the administrative setup, beginning from the grade of assistant director, which they also say in their paragraphs Y and Z. They also admit, which is meant only for officers whose appointment was being routed as graduate teachers. There would be gross deprivation of the rights of the graduate teachers and the higher secondary teachers who are in the promotion line in the school education department as per the seniority list of the department. So again, they are espousing the cause of graduate teachers and postgraduate teachers. It is further mentioned that if the petitioner is given further promotion to the post of additional director meant for the graduate teachers, otherwise than in the ex-cadre promotion lineup that will result as a gateway for other technical persons who are in the list next to the petitioner, and that will unquestionably create a chaos in the promotion line up in the department, depriving the rights of the members of the association, respondent number 4, and other officers of the department who are to be promoted as per the seniority list. 3. So this is their ground, your leadership. This is their ground. That my service is depriving the promotional rights of graduate and postgraduate teachers. I have progressed from the rank of assistant director to deputy director to joint director, and am now an additional director. Whose rights have I violated? These persons who they have named in leadership, these are not my immediate juniors also. Not someone who at that relevant point of time were eligible to be considered for promotion to additional director. They were not in the zone of consideration. They were not in the zone of consideration for promotion to even director. So this is their case. And the respondent number 4, the association, they filed an additional affidavit in the year 2018. This is dated 5/6/2018, your leadership. This is also another interesting affidavit, and it actually shows the power. 5/6/2018. The power which the association holds in the department. And has your leadership got it? Paragraph 1. that the private respondent number 4 felt necessary to file this additional affidavit because at the time of the filing of the affidavit in opposition filed by the respondent number 4, certain important facts were not known to the private respondent, and only recently such facts have been made known to the private respondent. Therefore, filing of this additional affidavit becomes necessary so that justice will be done to all the parties while this honorable court adjudicates the matter. That it is stated that only recently the private respondent came to know the existence of PNAR department approval dated 24/5/17, whereby after the careful examination of the official promotion of Limo Abang Iyer to the post of additional director, the PNAR department has conveyed its approval to the concerned department to immediately withdraw the official promotion order of Limo Abang Iyer to the rank of additional director and revert him back to the post of joint director as he was from ex-cadre. And what they have included, your leadership, is a file noting of the PNR department, which is Annexure A. May I read, your leadership? The matter has been examined and the following are conveyed. The school education department has made a serious error in promoting ex-cadre official to a cadre post of joint director. This has been further compounded by the ensuing promotions sanctioned against the cadre post, additional director, and allowing official in question continuing holding their first cadre post. These are grave infringements in the service rules as well as notification dated 21/7/11. Since the aforementioned rules notification does not in any ways provide for an ex-cadre official to be promoted and continue holding a cadre post, as such, the promotion of Engineer Libo Wawang Iyer against the cadre post of joint director and additional director needs to be revoked. However, with regard to the promotion to the cadre post of joint director, may not be feasible to review the same, considering that it had been already recognized by the Departmental Promotion Committee and also taking into account the fact that more than 4 years have now lapsed. As such, the present official promotion of Engineer Limo Abang Iyer in cadre post of additional director will have to be withdrawn, and in the event the department requires a service at the level of additional director, department may accordingly submit proposal for upgradation of its post on personal basis along with compelling functional justification. Now, firstly, your leadership, this remains just a file noting, no action taken thereon. But what is most relevant, your leadership, is at clause 5. Can you look at clause 5? However, with regard to the promotion to the cadre post of joint director, so I was promoted to the cadre post of joint director. And this cannot be reviewed. Now, your leadership, this noting seems to be motivated. The fact of the matter, it seems to be motivated. But the PNR department acknowledges that I was promoted to a cadre post of joint director. Someone else was promoted to the ex-cadre post of joint director. Someone else was promoted. So this is the case of the respondent number 4. Leadership, can we continue at 1? I'll place only the authorities now.
If the petition is allowed, now you said that you have already expired.
Yes.
So how does it benefit you?
If he is entitled to be considered for promotion to the post of director, post-retirement consideration can be done, your leadership. And if his case is considered for promotion and he is recommended for promotion, he will get the benefits of his promotion to the post of director. And those benefits will translate into receipts for his wife and children, your leadership, family pension.
Okay, let's continue.
At 1, your leadership?
1, yes.
At 2. At 2.
2.
No, my original, there is actually, we issue the copy.
No, that's why then my original is there.
So wait.
That's mine, my personal copy. That's why I'm marking personal. copy.
Please.
Lordship,
Yes.
beg to mention item number 25. Lordship, here I'm a complainant, so kindly, if your lordship may allow, kindly allow me to file AI for implement.
For implement of,
I may claim in 25
no.
to implement.
May I
The-
please, Lordship, I'm appealing on behalf of the principal counsel, DJ Haloy.
Hmm.
In fact, the counsel have instructed me that he had already taken the consent of the PP.
Hmm.
To make an adjournment, to seek an adjournment for 2 weeks.
Only 25 or 24 and 25
For 24 and
for
25.
both. 2 weeks,
Yes,
for 2 weeks. Just call the steno once, goes on. Steno.
Lordship,
Within-
I'm only
within-
mentioning item number 25.
Within that time, you can file, if you want to file your IA.
Okay,
Yes.
2 weeks, Lordship.
Counsel for the petitioner. This is item 24 and 25. Learned counsel for the petitioner, she said and such, appearing on behalf of Mr. DJ Haloy, has prayed for listing the matter after 2 weeks. Yes, wait. Stop prayers allowed. In the meantime, learned counsel for the, you're praying on behalf of respondent. Respondent number,
Lordship, I'm the complainant, so my,
no, because he is the petitioner in 24 and 25. Isn't it?
yes, Lordship.
So you must be for the respondent, which
Yes,
respondent?
Lordship, but Lordship, I'm not impeded here, so
likely the private respondent.
Yes, but
Otherwise, it's only PP, which is.
it's here it's only given PP. Okay, just say the private respondent in 25. Counsel for the private respondent, submits that he may be allowed to file an IA for implement of,
complainant,
who do
Lordship,
you want to implement?
complainant.
No, I don't understand what you're trying to say.
Lordship,
In fact, it's only an,
No, maybe you were not impleted
yes, Lordship.
in the anticipatory bill 15. That's why you want to be impleted as a
Yes,
party.
Lordship. I'm a necessary party here, so.
In anticipatory bail, is it necessary? It is not a POXO case or anything like that. If it's a POXO case, then complainant is to be impleted. Anyway, I'll just leave it, you file if you want to, we won't say anything, just list after 2 weeks.
Interim order, Lordship.
Interim order passed only shall continue till the next date.
Obliged.
Obliged, Lordship. May I also beg to mention hearing item number 21. On joint prayer, Lordship, can it be listed on Thursday, that is 19th of June?
21, on the prayer of the learned councils for the parties, list on 19th.
Obliged, Lordship.
Please, Your Lordship, I beg to mention hearing item number 20.
Yes.
Lordship, if this matter can be fixed on Thursday.
When?
Thursday.
Thursday.
That's right.
Okay, Thursday. List on Thursday, on the prayer of the learned council for the
Respondent number 5.
respondent. Yes. Learned council for the petitioner is also present. Yes. What about 22 and 23?
This Lordship, I beg to mention hearing item 23. Any this matter will be possible for the day.
Pass over for 23. And the prayer of the learned council for the petition. But 22 also may not reach.
In any case, it will not
22.
reach. So
That's why.
if we can be listed on, I don't know, the instructions of your senior. The CP will not be available next week and after vacation.
After vacation, post certification, with the consent of the parties.
Lordship, interim.
Interim order passed earlier shall continue till the next week.
Majo.
Yes.
Your Ladyship, if I may, just to one more argument of the respondent number 4. For that purpose, may I take your Lordship, your Ladyship once more to my writ petition?
Your petition.
Yes. At annexure A at page 21. The petition, annexure A at page 21, the post creation order. Post creation order, in the first paragraph, I am directed to such and such of pay indicated against a post plus all other advances as admissible under the rules from time to time for the Director of School Education, Nagaland, Kohima, with effect from the date of filling out the post up to 2289. So the argument has been taken that it was a post for a fixed tenure. A fixed tenure. But the fact of the matter is, me as the person who was appointed against this post, in fact, there are 3 posts. All these 3 posts have continued. I personally am not aware if there was any formal order. But the fact of the matter is, these posts have been continued. And as far as the state is concerned, they have not also taken up this issue. It is only the association. Now, then the other point which I was placing before your Ladyship earlier, it's about the noting of the PNAR in the additional affidavit. Additional affidavit dated 5/6, filed on 5/6/2018. 5/6/2018. Yes, and the file noting at annexure A and the 11 clause 5, which says that I was regularized in a cadre post. Yes, and then the date is important here, Your Ladyship. This is 24/5/2017. 24/5/2017. This is prior to the rules of 2017. Apart from the fact that it remains a file noting, and my promotion was not revoked. The rules came into force with effect from 29/11/2017.
This is
24/5/2017. Then, on the issue of locus standi and not being an aggrieved person, some pleadings of the respondent number 4, which I would like to conclude as far as the affidavit is concerned. At the affidavit in opposition of the respondent number 4, 15/6/17, the bulky affidavit, at paragraph R, at page 5. at the bottom of the page, the last sentence, the petitioner had been allowed to sit above the senior officers who had already entered in the zone of consideration for next higher promotion post to the rank of joint director. Now, the point of note here, Your Lordship, is I'm already an additional director. I'm not a joint director anymore. I filed a petition because I was barred from further promotion from the post of additional director. So these are the persons the association has filed or association claims to represent those persons who are in the zone of consideration of joint director. I'm already above the grade of joint director and then the grade of additional director. So those persons who are in the grade of, or who are eligible to be appointed to the grade of joint director have no locus standi to question my promotion to the post of additional director. I am already one step ahead of them. Then at paragraph Y, so again, ostensibly, if you had to read this along with paragraph, the earlier paragraph, Your Ladyship, at paragraph R, the two persons mentioned here are persons who are eligible to be considered for promotion to the grade of joint director. Yes. But again, these two persons are not the petitioners or the respondents before this honorable court. They are not the
They have
aggrieved.
said they are also the members of the association.
Yes, but the association cannot file because the association is not an aggrieved person. Only a person who is aggrieved can file. So these two persons have not questioned my appointment at any point of time. Then the last paragraph is paragraph Z again. Z, if the petitioner being appointed as a technical person, assistant engineer, is allowed further promotion in the administrative setup. Now, the point here is this, Your Lordship. I was appointed in the administrative setup from the very inception as assistant director. Those persons who claim that I am affecting their promotion are in the teaching cadre. So these persons have no locus standi to question my appointment in the administrative setup. More so, given the fact that they are espousing the cause of those who are in the zone of consideration for promotion to joint director. So that these cover the facts. Then the petitioner, Your Lordship, he expired on 7/3/2024. After his expiry, his wife filed an IA
7/3.
2024. His wife, the instant petitioner, filed an IA for substitution, and that application was allowed. And this honorable court, of course, it was the case of the applicant, but the order is dated 3/6/2024. And may I read, Your Lordship?
Yes.
This is an application filed by the applicant, who is the legal representative of the writ petitioner, who unfortunately expired on 7/3/2024. The learned counsel appearing on behalf of the applicant submits that the applicant herein should be permitted to pursue the accompanying writ proceedings on the ground that if the reliefs which have been sought for is allowed, the applicant who is entitled to the family pension will be getting a higher family pension. Taking into account the right to sue even continues after the death of the writ petitioner, this court substitutes the applicant against the writ petitioner. Accordingly, the instant petition application stands allowed. So this is the point which I was making earlier, Your Lordship. After the expiry of the petitioner, the right to sue survives. If the petitioner is found to have actually been denied his rights, then benefits will accrue to him, Your Lordship. And those benefits will translate into benefits for his widowed wife, for his widow. Now, if I may take Your Leadership to my list of authorities.
This list.
Yes. The first one, Your Leadership.
Yes.
One is 1996, one SSC, Promotion is not only to a higher post in the service, but it can also be appointment to the higher scale of an officer holding the same post. Promotion can either be to a higher pay scale or to a higher post. This claim about upgradation in leadership. And 1998 6 SCC, page 66. But posts can be created by administrative orders so long as they are not inconsistent with the rules. That is to say, as long as there is no prohibition in statutory rules for creation of such posts. So, your leadership will see in the rules of 2002, the rules provide that the state can create posts. 1998 8 SCC 469. Statutory rules prevail over executive orders or executive practice. Merely because the government has taken a decision to amend the rules do not stand obliterated. Till the rule is amended, the rule applies. So this was the point I was making about the prescription of the restructuring of 2011. The method of promotion is prescribed in the rules, so rules have to be followed, and rules were followed. Then 2010 SCC 166, the government cannot be permitted to blow hot and cold on the same issue. All along, your leadership, all along, I have been treated as a regular cadre officer. The PNAR also, in the note which has been filed in the additional affidavit, states very clearly that I was promoted to a cadre post. So can they blow hot and cold, especially by the different stands taken in the affidavits filed by the state? Then 2002 1 SCC 520, an affidavit cannot be relied on to improve or supplement an order. Equally, an order which is otherwise valid cannot be invalidated by reason of any statement on affidavit seeking to justify the order. So this is precisely the point which I was trying to make. Then 2003 2 SCC 632. We have carefully considered the submissions made on behalf of both parties. Questions relating to constitution, pattern, nomenclature of posts, cadres, categories, their creation, abolition, prescription of qualifications, and other conditions of services, generally the bar of the state, Your Lordship, as far as the post-public employment is concerned. Then 2004 12 SCC 588. In law, if an executive instruction is contrary to statutory rules, the rules will prevail and not the executive instructions. Now, in the context of the 2002 rules and the 2011 restructuring, and the 2011 restructuring in the context of the 2017 rules. So now 2017 rules will prevail, Your Leadership, and 2017 rules does not bar me from being considered for promotion to the post of director. Even the 2002 rules, Your Leadership, even the 2002 rules does not bar me from consideration for promotion to the post of director. Then 2004 3 GLT, this is about accrued rights. So all along I have been treated as a cadre employee. Out of the blue, at the instance of vested interest, that vested right cannot be taken away. Then 2006 3 SSC 208, the order passed must be judged on the basis of the contents thereof and not as explained in the affidavit. This is a well-known principle of law in leadership. And 10, when terms and conditions of service are governed by rules framed under Article 309, there can be no alteration or amendment of the rules by executive action. Same ground here, Your Leadership. 2002 rules, 2017 rules, they do not bar me from being considered for promotion to the post of director. Then 11, 2007, 10 SCC 513, an employee has the fundamental right to be considered for promotion. So the corrigendum bars me from being considered for promotion. That also in violation of the rules. Then 2010 3 GLT 150. The state cannot take a stand which is contrary to its own conduct. So all along, I have been treated as a cadre employee. All of a sudden, at the instance of vested interest, a contrary stand has been taken. 2013 4 SCC 465. Only a person who has suffered from legal injury can approach a court of law. The existence of a statutory duty and the legal right to seek the performance of such duty is a condition precedent for invoking the writ jurisdiction. The exercise of the writ jurisdiction must be to enforce a legal right. A legal right means an entitlement arising out of legal rules. So here, Your Leadership, how is the association agreed? What right of the association has been violated? Then 14, Your Leadership. 2014, 8 ACC 644. Executive orders cannot supplant the rules. Executive order can only supplement the rules. Well-known principle in addition. So even the earlier stand of the state respondents that the restructuring of 2011 cannot be read in isolation. It must be read in accordance with the rules. Then 15, the last one in the edition, 2015, 12 ACC 669. Having held out a promise for appointment and for benefits thereunder, which the petitioner accepted, the state is bound by the said promise. The petitioner's position thereof cannot be altered adversely in breach of the said promise. Advertisement, Your Ladyship. A post under the Directorate of School Education. I applied. I was assured that there would be a service, there would be a career progression for me. All along, it was given to me. And all of a sudden, at the instant of vested interest, that has been taken away from me. So these are the authorities on which I'm relying. Your Ladyship. I have not bothered to take Your Ladyship to the entire paragraphs, but the principles which I've colored from these authorities. May I rest for the moment, Your Ladyship.
What about this WBC 29? Oh, there, dear, the petition.
That is their petition, yes. This is again. Just the cause title, may I take your leadership to the cause title? I filed my affidavit of opposition. It's more or less the same thing which the facts and the grounds which I've taken in my petition, and the replies I've made to the affidavits filed by both the state as well as the private respondent. Has your leadership got the petition?
The writ petition.
Yes, the writ petition. The petition, WBC 29 of 2020.
Yes.
And the array of parties, your leadership. Thank you. Now, your leadership, the array of parties at page 3. The first petitioner is again the association. And the second petitioner is an assistant director. Someone who is at the entry stage in the administrative setup. And I am already in the grade of additional director. So they have no locus standi to challenge my appointment or my further promotions in the Directorate of School Education. I have filed my affidavit in opposition, your leadership, and the grounds that I have taken, your leadership may see that in paragraphs 2. I'll just mention the paragraphs if you wish.
Respondent 4.
That's filed on 6/10, respondent number 4, 6/10/2021. So, yes. The grounds I've taken is paragraph 2, 3, 3, 4, 5, 6. Those are the main grounds that I've taken in each. 2, 3, 4, 5, and 6. And of course, I've counted each of the amendments in the paragraphs of the petition in the remaining paragraphs. So that is all.
Yes.
Yeah, please, Your Lordship. Lordship, in fact, I am not physically ready to argue today, but seeing the period of pendency of the matter, where it comes very
You
costly.
seem to be
So, yeah, mostly I'll rely on the affidavit and opposition, as well as the additional affidavit, which we have already filed on 12/11/2018. But just want to highlight some points on it. That is a very vital and key issue in the present case. You see, Your Lordship, here, service condition of the officers working under the Nagaland School Education are covered by the Nagaland School Education Service Law 2002. So in the present case, as we always talk about the blood is thicker than water. So if it is so, if we go by that way, the petitioner will be a water, not a blood. You see, in a human body, the scientist, medical scientist says that the average weight of the body is, say, covered 55 to 80% of the, in our human body weight is covered by the water. But still then, without blood, what is it cannot do? So also here, your lordship here, the petitioner is not a caterer, he's not a confirmed service. So that is the issue here. And if you come from the top, then definitely everyone will be confused. But if you just track from the very beginning, now why the SLAT all the time target Iran, and they just where the missile was initiated emerged, they are pulling up that thing. So same thing as per the civil soul to 2002. The petition was not a confirmed officer of the department. So his services.
No, he was already confirmed. Confirmation is there by the DPC.
Lordship, but in the civil soul it is not there. And one more issue is I want to place before Lordship is, had the petitioner challenged the civil soul 2002, then that's also another question. But without challenging, as per the civil soul 2002, he is nobody. Whatever be the capacity of the different capacity of the service, he has rendered a service that is okay, but it's not covered by the service role. So he was outside the service role. So that is the only case here.
The government itself has been promoting him in the caterer post.
Yes, your lordship here, since he was accommodated in the department and as per the service role, rule 7, service role 2002, rule 7. I may be allowed to read it because there is a scope for the department to accommodate two types of services. Rule 7 clause A, Rule 7A clause 1, Roman letter 1. May I read, lordship?
Yes.
Notwithstanding anything in these rules, if in the opinion of the government, the expenses of the services should require the government be by order of the consulting the commission, if necessary, adopt any method of requirement to the service other than those specified in these rules. So petitioner is accommodated from here. And if you go by that, again, the service rule, that annexure 1 to my affidavit in the opposition, page 18. No. Page 17. That is schedule 2, serial number 2. Here, additional director is there. The petitioner, at the time of requirement, he was holding the additional director post. So as per this,
Schedule 2.
schedule 2, page number 17, schedule 2, serial number 2. Here it is clearly mentioned, the post of additional director shall be ordinarily be filled by promotion on the recommendation of the committee. Selection shall be made from among the confirmed officers, provided he has completed the qualifying service of 22 years in the school education department and at least 3 years as joint director. So lordship here, as per this service role, he was not a member and he was not covered by this service role. That is one point. And that is the crux of the case. And your worship, it is very clear and admitted that the petitioner was appointed as assistant engineer and upgraded to, again, system analyst, and again upgraded to the executive engineer. And thereafter upgraded to the again joint director, upgraded at last, upgraded to the additional director, upgradation only. Because of that rule 7, he was upgraded only. So it makes a difference, your lordship. So I will be allowed to refer only that, as I stated earlier, my affidavit in opposition, paragraph 3. I will just conclude my submission. My affidavit in opposition, paragraph number 3, 13, 15, 17, 18, and 23, which I'm going to rely. And again, I have filed another additional affidavit by the order dated 24/9/2018. So which was filed on additional affidavit filed on 12 November 2018.
1 minute. 12th November.
12 November 2018. Affidavit, but
Says
it
that
is,
in compliance with the order.
yeah,
In compliance with the order dated 24/9/18.
24/9/2018. So there, para one is exhaustively we have explained. So I rely on that. Again, Lordship here, in as per the Civil Code 2002, he was not covered by that rules. Again, the department has again published a rule 2017, and 2017, the pause of the petitioner, it is specifically mentioned in the Section 2, serial number 15 as ex-cater, assistant engineer. So this page 45. Section 2, serial number 15, ex-cater. That is a initial pause which was doing, petition was doing. And thereafter upgraded up to the additional director. So my humble submission rely on that my affidavit that he was not covered by the both the Civil Code 2002 as well as by 2017. So whatever may be a submission made by the petitioner, it has to be decided and it has to be again rolled out only by the Civil Code. So by the Civil Code 2002 as well as the 2017, of course 2017 it is not applicable at all. But if you compare the pause of the petitioner as per even the latest Civil Code is ex-cater only, and for which in the earlier Civil Code also was an ex-cater, for which that is a defense of the state respondent here. So
Upgradation was only once to the post of joint director.
joint
Then after
director,
that, all others are promotion.
whether upgradation is there, but promotion also, but whether the petitioner is it is governed by the service role or not, it has to be looked into again.
No, that aspect is there, but another aspect is that the government itself has been promoting him to a cadre post.
Cater, but your lordship here, from where he started footing, that we cannot ignore the footing up the starting of the petitioner, his service life. So whether he was come under that rule, governed by the rule or not, it cannot be ignored. Whatever be the decision are by the noble court, but what the service role, we cannot ignore on that. So with you submission, I will conclude my submission here, but I may be allowed to reiterate that the paragraph which I mentioned in the affidavit in the opposition, as well as in the additional affidavit that may be relied upon while determining these issues. Thank you, ma'am.
The affidavit, second affidavit is 12/11/2018. Yes. You are responding number 4.
My lord, yes. We're used to address this noble court, my lord, so I may address as my lord.
No problem. Yes.
May I please, lordship. In fact, this case has been kept pending since 2016. In 18, 3 days argument was taking place. Then after that, the matter was somehow adjourned, and that matter has been listed today. Now, the first thing that I want to clarify before I come down to the argument is the counsel for the petitioner has referred that I'm only graduate teacher, Locus. Now, the association, Nagaland School Education Administrative Officers Association, consists from graduate teacher up to director. These are for welfare association only. Consists up to director. Graduate teacher up to director. I have confirmed. So that is one thing I want to clarify it. Because affidavit itself was filed by one assistant director, not by the graduate teacher. No doubt. Even otherwise, senior graduate teacher are all considered Gazette class 2 as part of the rules and in terms of ROP. Now, after arguing for 3 days into 18, I have decided to change my approach. That I'll shorten.
Now it's
Shorten,
hopefully
concise, and then I'll give short facts. Only short facts so that it will be convenient for the court also. So I have prepared short facts so that it will be easy for reference. I can give a copy to the court also. I'll just read out after that. I'll refer to the service law and then the judgment. Short facts of on the R4. 1. Petitioner Engineer Lim Wawapang was appointed as Assistant Engineer Electronics by an order dated 18/4/1990. His appointment is annexed as Annexure B at page 22 of the writ petition. My lordship, whether I need to refer to that, not required. Wherever I'll just put it out. B, by government notification dated 29/2002, the Nagaland School Education Department Service Revised Rules 2002 was brought in force. 3. Under Rule 4, all cadre posts have been classified wherein the post of assistant engineer is not mentioned, meaning thereby it is an ex-cadre post. 4. Further, Schedule 1 of the Rules 2002 provides the total strength of the cadres in the directorate. Nowhere in Schedule 1 mentioned that the post of assistant engineer held by the petitioner is a cadre post. Normally, an ex-cadre post means post outside the cadre post comprised in service. Therefore, the post held by him was an ex-cadre post in terms of Rules 2002. Now, I just come, before I proceed further, I just wanted to show this honorable court about the rules. I'm saying my contention is that his post is not at all under the rule. There's no mention of assistant engineer. My lord will see the law is settled. If the post is not mentioned in the Schedule 1, Schedule 1 means strength of the cadre of the department. Schedule 1. As per Supreme Court judgment, unless the post is mentioned in the Schedule 1, total strength, where it is mentioned total strength, then it's ex-cadre post. I'll show the law. Schedule 1, page 11. My lord, all rule, yes. 2002. Schedule 1, my lord. May
Yes,
just check?
we've seen
Yes. Director, additional, joint director, deputy, senior research, all this. So here, this is the total strength of the cadre. Nowhere it is mentioned as assistant engineer. So that is my argument. Lordship will appreciate one point. In addition to that, these are all drawn from PW department. Supposing social welfare that have engineer technology cell. For any construction, they're attached or they're appointed there for particular, but that they don't form as part of the cadre. Even here in education, for any construction building, they are consulted, they make blueprint, everything, but they are not part of the cadre. This is what I'm trying to say.
His post was created in the education
But
department.
correct. Post is the post was appointed as ET cell, education technology.
Yes.
Education technology. But that does not fall under the cadre post, because the posts that are whatever posts fall under cadre post are all mentioned under the schedule 1. This is the total strength.
Okay.
So therefore, as far as the issue of cadre post and ex-cadre post is concerned, even under Rule 4, as I have said, there's no post mentioned as assistant engineer. So Schedule 1 also clear that his post is not there. While talking about the rules, I'll just draw this court's attention to the Schedule 2, where it is specifically mentioned as Schedule ex-cadre. Same rule, Schedule 2. Schedule 2, serial number 18, specifically mentioned as ex-cadre.
Serial number 18.
18. May I read it? Official in charge, ET cell. On the left, on the right side, my lord. Once the present incumbent official holding ex-cadre post, are promoted or retired, the post vacated by then shall cease to be ex-cadre. Now, when he was appointed as assistant engineer, ET cell. Money education technology, huh? In
ET cell. Yes.
ET cell. So that is absolutely ex-cadre post. That is, there is no ambiguity, there is no doubt about that. It is ex-cadre post. Once they retire, that fellow incumbent retired, that will be done away. So therefore, in terms of this Rule 2002, the post held by the petitioner at that time, 1990, was ex-cadre post. That must be make it very clear. Now, my lord, I'll proceed. Come to point 5. Seniority of the cadres are governed by Rule 17 of the Rules 2002. Under the Directorate of School Education, the department maintained two separate seniority lists, namely A, officials of elementary and secondary education, B, officials of higher secondary education. The association fall under officials of elementary and secondary, but the petitioner, unfortunately, he is not from administrative, therefore there is no seniority at all for him. I am not against anybody, but I'm talking about the rule. Under the seniority also, I have said it here. Nowhere his name has been mentioned in any of the seniority because his post is outside that cadre post. 6. The Directorate of School Education Department maintained the seniority list and the seniority list between 1990 to 2011. The name of the petition never appeared in the seniority list as he was holding a technical post as assistant engineer, subsequently upgraded to the executive engineer, which are outside cadre posts. The seniority list of 1990 to 2011 is annexed NHA to the affidavit in opposition filed by me, R5, page 16 to 96. There, my lord, here, next point. For almost 10 years, his name was never there in the seniority list. Meaning thereby he doesn't come under that category cadre post. Still, there was no objection. He had not come to court to redress the grievances during that period. 1990 to 2011, I have annexed all the seniority lists. Though I think I don't need to read the seniority list because I have annexed and I have given the page also.
Okay.
Like I said, I just want to shorten that argument.
And next year, page 16 to 96.
To my affidavit. Yes, I have had. So, nowhere his name appeared, petitioner name appeared, because he is from ex-cadre post. He is not part of the cadre post. And that fact he cannot deny because nowhere he has denied about that. And document speaks volumes that he is not part of cadre post. Then I'll just proceed further.
Yes.
7. By an order dated 24/10/2003, the post held by the petitioner as assistant engineer electronics was upgraded to that of executive engineer class 1 gazetted upgradation, along with the incumbent and designated as system analyst. System analysis is declared as ex-cadre post, I'll show. Since the post held by the petitioner was an ex-cadre post, there cannot be regular promotion. Therefore, upgraded the post along with the incumbent. The upgradation post dated 24/10/03 is annexed as NHSC to the repetition page 23. Now, my lord here, lordship, with your experience now, for all the cadre men, the proper channel of promotion is regular through proper promotion, through DPC, regular promotion. But in the case of cadre, ex-cadre, since they are not part of the cadre, so they cannot be given regular promotion. So therefore, the only way to resort to by the government is by way of uplifting for he himself, he alone. The moment he retired, post will be vacated. That is the meaning of ex-cadre upgradation. So therefore, to the post of executive engineer, his post was never promoted through regular promotional general promotion. Why there was no promotion, only upgrading? Because the post is not regular post. Therefore, it was only by way of upgradation. Meaning thereby the post is outside that cadre post. May I proceed then?
Yes.
8.8. The petitioner had never challenged the rules 2002, which govern the terms and conditions of the services of the employees. Under the same rules 2002, the post of assistant engineer and executive engineer were made ex-cadre. Therefore, his service was governed by rules 2002 till the new rules 2017 came into force with effect from 29/11/2017. He was appointed in 1990. New rule came. The writ petition, this writ petition was filed before new rule came in. Writ petition was filed in 2016. Therefore, rule came only 17. It will not have retrospective. That's what I'm trying to say. Now, another important aspect is revamping and restructuring policy 2011. When the old rule 2002 was in existence, government came with a wisdom that no, we have to create some avenue out or something. So they want to revamp. So therefore, policy was formulated. Now, point 9. By a notification number so and so, dated 21/07/2011, in the interest of public service, the governor of Nagaland was pleased to order for revamping and restructuring of the school education department. In the restructuring policy, the service of system analysts, planning and vocational education are ex-cadre posts. In the revamping policy, these are called ex-cadre posts. And when His post was upgraded from assistant engineer to executive engineer. It is specifically mentioned senior and system analyst. That is by order 2003. So now that promotion effected in 2003 has been reaffirmed by this revamping policy 2011, where it is specifically mentioned that this engineer, the education, vocational education, system analyst, all these are ex-cadre posts. The last promotional post for ex-cadre post was the additional director NHSC, page 116 and page 118 of the affidavit in opposition filed by R4 by me. I think we can show that. I'll just show that portion where it is shown. Page, my lord, page 116. What I'm trying to show is my lord, I'll come straight to 118, where it is mentioned system analyst is a ex-cadre post. My lord, page 118.
14, serial number 14.
Column 14. The post shall be filled. This is joint director. The post shall be filled by promotion of the senior most member from amongst the confirmed members of the service of ex-cadre of planning and vocational education, including system analyst. So therefore, system analyst is always remain ex-cadre, not cadre. Correct? Now, come reverse side, 116. I'm trying to show to this number code that his post is all along ex-cadre. Then page 116, this is revamping policy program. 116 clause 7. The last paragraph. The post of additional director planning will be the last promotional venue for the members of ex-cadre service of education. Members of ex-cadre. Now I'll continue with the my submission. Point 9, continuation. When the assistant engineer electronics held by the petitioner was upgraded to that of executive engineer, and this point number 9, my lord.
Yes.
I am continuing.
Yes.
When the assistant engineer electronics held by the petitioner was upgraded to that of executive engineer and designated as system analyst, which had been made as ex-cadre by the revamping policy 2011, was never challenged by the petitioner at any point of time. In this instant case, since the petitioner has already availed the service benefit and got promotion to the post of additional director under the revamping and restructuring policy 11, he cannot turn around and challenge the corrigendum dated 21/03/15 issued by the commissioner and secretary to the government of Nagaland. He is barred by the principle of approbation and reprobation. In fact, had there been no revamping and restructuring in 2011, the petitioner had no further promotional scope beyond the executive engineer under Rules 2002. Point 10. That the petitioner, after accepting the revamping and restructuring policy of 2011, and based on such restructuring policy, they, by a common promotion order dated 02/09/11, the petitioner, along with 18 others, were given officially promotion to the post of joint director, which was duly accepted by the petitioner. In fact, at the time of giving official promotion to the post of joint director, the petitioner, Engineer Lim Awapang, was holding the post of executive engineer. Here, the most important point comes here. Transposition, the law of transposition. At the time of giving official promotion to the post of joint director, the petitioner, Engineer Lima Wapang, was holding the post of executive engineer designated as system analyst, but not the post of deputy director as feeder grade. However, the record had been manipulated and manufactured at the time of giving official promotion to Engineer Lima Wapang to the post of joint director by wrongly showing that the Engineer Lima Wapang was holding the post of deputy director as feeder grade in a very suspicious manner. Such fraud had been committed by some official in the department to help the petitioner to enable him to jump from ex-cadre post to the cadre post. It is a clear case of transposition from ex-cadre post to cadre, which is bad in law. Now I want to show only one look. I want to show because when Engineer Lima Wapang was upgraded to joint director, in the order, it is mentioned as deputy director. Why? Because if it is shown executive engineer, he will not get promotion because he is not from the cadre post. Page 59. Page 59 of the read petition, NHE. Therefore, the transposition comes. That's why I filed co-warrant of petition to oust him, but he retired, unfortunately. Before this one could oust him, he retired.
Page 59.
Page 59. Serial number 3. Lima Wapang, deputy director, present deputy director, now promoted to joint director. Where is that deputy director order for him? Where is that? Now, last on the right side, it is always written upgradation. So Lordship was putting one query to my learned AG, only one upgradation. There are two upgradation. One is from assistant engineer to executive engineer, and another is from deputy director to joint director. Two upgradation orders. Two. Now, yes, now this is upgradation, my lord. Now the question here is, in fact, on this issue, my lord, on this issue, in 2018, when we argue for 3 hours, let a single judge realize, all right, whether there is any order by which Lima Wapang had been promoted to deputy director, is there any order of conversion?
Designating.
Conversion order, designating from executive engineer to deputy director. Is there any conversion order, designation order? So that was disputed. So after hearing 3 days, let a single judge order government to file to that effect.
That affidavit.
Yes, whether factually there is any such order by which the post of executive engineer has been designated as deputy director. If not, it is a clear case of transposition, which is bad in law. That is my submission, which is bad in law.
Your leadership,
I'm coming to that.
this is not a correct statement. I must correct that. The
The
affidavit which was directed to be filed was to the effect of whether the petitioner was promoted in terms of the 2011 notification or according to the rules.
I have
Not this
reproduced.
point.
I have reproduced the affidavit.
Not
in my
this
argument.
point.
No, it's the affidavit which was read out just now, isn't it?
Yes, by the state.
I
By
have
the state.
Sorry, I'll come to that.
In fact, the state's affidavit is very clear. It is not what my other friend is saying. That is a wrong statement, Your Leadership.
Now my argument is this.
No,
Whatever
if I
it
remember
is.
correctly, that the issue was never there.
Yes.
Whether he designated as director.
I'll come to that. I'll come to that. Now, my lord, what is this? The most important point is this. Since his last upgradation post was assistant executive engineer, and that also designated as senior analyst, which is ex-cadre. Now, after that was 2003. After 2003, whether there is any government order by which the post of executive engineer in respect of Lima Wapang had been designated as deputy director. If it is not there, it is a clear case of transposition. Bad in law. I'll show the law. Though the matter has been filed in 2016, till today, he could not produce any order showing that his post was converted from executive engineer to deputy director. Nowhere, no record to show. That may be, that is very important, my lord. Very, very important. They could not the petitioner could not satisfy the court on that point. So therefore, because of that, I filed quo warranto petition, but like I say, he retired before we could dispose of the case. Now I'll continue. 11. As per clause 3 of the common promotion order dated 209/11, the official promotion to the post of joint director was issued on the condition that the official should obtain B.Ed degree within 3 years as an exceptional. The petitioner had not obtained the required qualification till he retired from active service. Clause 4 also clearly states that next promotion will not be considered if the requisite qualification is not obtained, which can be seen from Annexure E, page 59 of the writ petition. I'll just show lordship that document. Whether he has fulfilled to be promoted to the post of page 60, my lord. Continuation, page 60. Page 60, my lord. Condition 3 and 4. The official promotion is issued on the condition that the official obtained B.Ed degree within 3 years as an exceptional case. 4. Further, the next promotion will not be considered unless the official obtains the requisite qualification as per the service rules of the school education. The official promotion is made purely on temporary basis and subject to regulation by the departmental committee. Throughout his life, till he retired, he retired in 2021. He retired in 2021. Till he retired, he had not obtained B.Ed education. Why department had put this condition at the time of promotion is because these are administrative posts. He is from engineering wing, who is supposed to give the blueprint for construction, if any, in the department. So therefore, when he has not qualified, when he has not fulfilled the conditions of the promotion, official promotion to the post of joint director, how could he claim to be the additional director now? 12. I'll just continue. In the year 2012, the name of the petitioner, Engineer Mawapang, was published in the tentative seniority list of 2012 as joint director, which was objected by the members of the Nagaland School Education Administrative Officers Association. As such, it was rectified in the year 2015 by showing the name of the petitioner as ex-cadre, which was never challenged by the petitioner. Therefore, the petitioner had already accepted that he belongs to ex-cadre, which can be seen from Annexure D at page 134 of the affidavit in opposition filed by R4. My lord, page 134 is the cover letter, my affidavit, R4's affidavit. Then relevant page is 135. Number 2, serial number 2. Engineer Mawapan Iyer, heading ex-cadre on the top, ex-cadre. So his name in the seniority list, his name was shown as ex-cadre in 2012, which he failed to challenge, 2015, which he failed to challenge at the right time. I just want to show about that. Now I'll proceed. Point number 13. On 14/8/2012, on the recommendation of DPC, the official promotion of Engineer Lima Wapang, along with 47 others in different posts, had been regularized. The name of Engineer Lima Wapang appeared as serial number 10 and regularized for the following post. 1. At one go, his post was 1. Assistant engineer with effect from 18/4/1990. That is his entry point. System analyst, that is ex-cadre, with effect from 24/10/2003. Then there is no deputy director post here. joint director with effect from 2/8/2012. Where is that deputy director post? There's no order to show that he was holding the feeder post of deputy director before giving joint director. That is the point. The whole case on this is this. So therefore, bad in law. Now, if that document, if lordship want to confirm page 67, but I have written.
We have already
Yes,
seen.
I have written so. So now therefore, meaning thereby, he was holding the post of assistant engineer when he entered the service, which was escalated. System analyst 2003 escalated, upgraded. Then no deputy director post. Deputy director post was never declared, not because he did not hold the post deputy director before he was promoted to the post joint director. Only by way of manipulation, the post of system analyst, executive engineer was shown as deputy director and given upgradation to joint director. This is the whole problem on joint director on 2/8/2012. Therefore, it is clear that he had never held the post of deputy director in his entire service career. The recommendation of DPC can be seen at NHR 9, NHR G, page 66 of the read petition. Hence, the petitioner had manipulated the records and shown his feeder grade post as deputy director and not as executive engineer, which was designated as system analyst. If his post feeder grade post was shown as executive engineer, he would not get regular promotion to the joint director. So somehow he had to manipulate the designation. There he had shown deputy director. Now my demand on that 2018 was, where is your order? Show me if you were in the administrative line. Show me. Unfortunately, during his lifetime, the petitioner could not produce any document to show that he was holding the post of deputy director at any given point of time. Then 14. By another order dated 9/6/2014, the petitioner was given official promotion to the post of additional director. Officiating promotion. My lord will see one more point here. He retired as additional director on officially. And law is very clear also. Law is very clear. Official has no right to claim any as a matter of right. By order dated 9/6/14, the petitioner was given official promotion to the post of additional director without fulfilling the criteria and the requisite qualification prescribed under Schedule 2, serial number 2 of the old rules 2002, as he had neither completed 3 years of continuous service in the grade of joint director or obtained BA degree. On that day, he was given promotion to the post of joint director, additional director. He had completed only 1 year, 10 months. Such promotion was divorced the rules. Now, my lord will appreciate. He was given official promotion to the post of additional director. With that, without regulation, he retired. He retired in 2021. Yes, he retired as additional director on officiating. I'll show the document. 15. By a corrigendum number so and so that at 21/03/15, Secretary to the Government of Nagaland had partially modified the promotion order dated 9/6/2014 in respect of Engineer Lim Wawapang prior to the effect that the petitioner will not be entitled to claim future promotion against any cadre post of director. The said corrigendum dated 21/3/15 can be seen at NHR J, page 75 of the writ petition. As stated in the foregoing paragraphs, neither under the rules 2002 nor under the revamping and restructuring policy 2011, the post held by the petitioner was never treated as cadre post. Therefore, the state government had rightly corrected the error appear in the promotion order dated 09/06/14, whereby the post held by the petitioner as additional director on official basis was shown as cadre post. As a result, the action of the government rectifying the error does not amount to illegality. 16. That against the corrigendum dated 21/3/15 issued by the state government, the petitioner has filed the present writ petition challenging the legality of the corrigendum. 17. It is relevant to point out hearing that on 24/09/18, the matter was listed for hearing before the learned single judge of the Gauhati High Court. During the course of argument, the learned counsel appearing for private respondent number 4 submits that there is no order or notification by which the post of executive engineer held by the petitioner was converted into deputy director at any given point of time. It is a case of transposition which is bad in law. After hearing the learned counsel for the parties, all the parties, the learned single judge by its order dated 24/09/18 had directed the state government to file an affidavit on the issue as to whether the post of executive engineer held by Engineer Lima Wapang was converted to deputy director prior to 02/09/11, giving official promotion to the post of joint director. In compliance with the court's order dated 24/9/18, an affidavit was filed by the additional secretary to the government of Nagaland, Directorate of School Education, and clarified that the post of executive engineer was never converted as deputy director. The said affidavit is part of the case record in the present case. The relevant paragraphs of the government affidavit is reproduced as under. Quote, para 1B. The petitioner was never appointed as deputy director before his official promotion to the post of joint director via notification 02/09/11. It may also be mentioned may I continue?
Yes, yes.
It may also be mentioned hearing that the post of executive engineer / system analyst was never converted to deputy director. This is the government's language. C. That as the post of executive engineer / system analyst is not included as one of the regular cadre posts in the Nagaland School Education Department Service Rule 2002, the official promotion of the petitioner to the post of joint director, via notification dated 02/09/11, was not made from the feeder post of deputy director. The official promotion was by way of upgradation as reflected in the notification dated 02/09/11. The upgradation was done pursuant to notification dated 21/7/11 and not as per the Nagaland School Education Department Service Rule 2002. D. Government affidavit. I have read this one. The upgraded post of executive engineer class 1 gazetted, which was redesignated as system analyst by notification dated 24/10/03, is not included as one of the regular cadre posts in the Nagaland School Education Department Services Rules 2002. Therefore, as per the Nagaland School Education Services Rule 2002, the post of executive engineer / system analyst is not equivalent to the post of deputy director in the school education department, unquote. Thus, it is a clear case that the petitioner was holding a technical post and never held any administrative post as deputy director. 18. That after coming to know that the petitioner had illegally jumped from ex-cadre post to cadre post in the rank of deputy director and joint director and usurped the power, the private respondent number 4, the Nagaland School Education Department Administrative Officers Association, represented by its president and one Propap Oza, assistant director, has filed a quo warranto petition registered as WPC number so-and-so 2020 against Engineer Lima Wapang to oust the petitioner from holding the post of joint director and or the additional director, which is pending for final disposal. This is next WPC this, but unfortunately he died and he resigned. So quo warranto may not survive. The moment he is expired, that is the law. Yes. Once the man is out, I cannot out, court cannot out him. So it will become infractions. 19. That much after the petitioner's promotion to the post of additional director, and also after filing the present writ petition, WPC number 192 of 16 before the Supreme Court Kohima bench, the new rules called Nagaland School Education Department, Nagaland School Education Services Rule 17 came into force on 29/11/2017 under Schedule 1. Under Schedule 1, under the heading as gathered, there are 9 posts. The relevant page is at page 27 of the rules. The last promotional post is that of joint director, and the feeder post is assistant engineer. In the new rule, the entry point assistant for the feeder grade is assistant engineer. Then from assistant engineer to climb up to the last post is joint director for the excavator. So therefore, as assistant engineer, when assistant engineer is excavator post, the ladder to climb up is joint director. So how can petitioner say that it is cadre post? I have page 22 rule of the rules. Page 27 rule. Page 27.
Yes, we have seen.
Then coming to 14 excavators. So now from these are the excavator. Then for the post of assistant engineer, column 2, assistant engineer to the joint director, these are excavator posts. The heading is very clear, not cadre post, excavator post. And the posts are assistant engineer, from assistant engineer to joint director. Because joint director, the feeder grade is assistant engineer. But I'll just continue. Under Schedule 2, under the heading excavator, also clearly provides that the post of joint director is the last promotional post for the excavator post. In the case at hand, the matter can be examined only under the old rules, as the petitioner entered into service under the rules 2002 and got promotion prior to 2017. The writ petition has been filed in 2016 prior to enforcement of Rule 17/20. The petitioner, Engineer Mowapang, while serving as additional director on official basis, has already retired from service on attaining the age of 60 years with effect from 31st/8/21. His retirement has been taken place before regularizing the official promotion to the post of additional director. That being the position, the petitioner should have been released as joint director as per service law. How can the Supreme Court is very clear? There are a lot of judicial pronouncement that unless a person regularized, how can he be given regular retirement benefit as additional director? He should be in fact given as joint director only, because at the time of retirement he was holding only official promotion. That is my argument. However, the release order dated 27/8/08/21 reveals that he retired as additional director, which is contrary to the law. In the light of the facts and circumstances stated above, the petitioner has miserably failed to make out any case for the indulgence of this honorable court. That is, the present writ petition is liable to be dismissed. Like I have said, in 2018 we took 3 hours, so today I have just shortened so that it will be easy to save the precious times of the court. Now I'll just show few judgment in support of my citation list. In support of my contention, I'll just show some citation list.
There are some judgments here also. Who was submitted?
Yes. Last time also we argued, so we had supplied lot of judgment.
It was all his.
Okay. 96, 1 ACC, 562, then
So
1
yes,
Kohima bench.
As usual, I just submitted my list of authorities with the principles,
This can be, same thing can be done here. So I have given the principles here, if that is so.
That is easier.
Easier.
That is easier.
My lord, I'll just 1, 2. I'll just score off. This is not. Or can we give up the sometime that I'll correct, because I want to drop 1 or 2 here from here.
Okay, there's one list of citations here also.
I'll just give it
Respondent for.
I'll just give you straight.
GLT 2015
No.
2899. This one.
On that is on
That
locus.
one is one
Locus-
1981 one is C 246. The same list, I think.
Yes. Then now definitions of cadre post. Year 1984, if lordship has the same.
Year 1984 SC 1595.
Yeah, that is definition of cadre post. Who are cadre posts? That is very relevant judgment. Unless the post falls under the Schedule 1, the post held by petitioner is not cadre post. This is what Supreme Court judgment says. Then transposition. Without holding the post of deputy director. Next, 1997, volume 3, SEC.
That one is not here.
Then give this.
Then you give the updated list.
Yes. Huh? Just give this one. No,
You remove this one again. So,
my lord, that is, then next is.
Transposition 1997 3 SEC.
Correct, because he had never held the post of deputy director. Only by showing a wrong feeder post, he could be promoted to the post joint director on official. Transposition, huh? Then next is, without revamping policy 2011, he would have remained executive engineer. But he has accepted that promotion to the post joint director. And now he said that that is wrong. So reprobation, approbation. I have shown the judgment 2009 volume 6 SEC. That is not permissible. 3 judgment 2010, 1981.
1981.
Yes. And then next is order banning, because deputy, without holding deputy director post, he cannot become joint director addition. So therefore, order bad in inception. I have shown that. 2011, volume 3, SEC. Then official, last judgment is official promotion has no right to the post, no locus standing. While holding the post of additional director on officiating, he retired. He is claiming the benefit of director. What right he has, what right has accrued to him to ask for the benefit of director? No doubt he's no more. We don't want to say anything on that. But we're talking about the law. Now, to sum up, the fear of the association. The fear of the association. There are some more medical doctors there, technical people. So we are from administrative staff, graduate to director. We are called association, that graduate teacher to director. Now, one medical director is the doctor, some are there. Technical staff, they were brought to the department now. And that the moment this case is decided, they are going to jump into the administrative line and they are going to claim the promotion, saying that they are also cadre post. So this is what the association has in mind. So to sum up, in my respectful submission, the petitioner could not make out any case to claim the financial benefit for the post of director. Therefore, this case is a fit case to dismiss. Much obliged.
Short points in reply. Sure. The first point is, first rebuttal is against, of course, the arguments advanced by the state. The learned additional AG has relied on Rule 7, Clause 1 of the rules of 2002 leadership.
Yes. 7 plus 1.
Yes, basically this is the aim. Keeping everything aside, this is the main point which the state wants to rely on. And this says, notwithstanding anything in these rules, if in the opinion of the government, the exigencies of services so require, the government may, by order after consulting the commission, if necessary, adopt any method of recruitment to the rules other than those specified in rules. So what are the rules, the specifications with regard to the recruitment in the rules? One is by direct recruitment and the other is by promotion. So if the government wants any exigencies of service, it may resort to any other method of recruitment after consultation with the commission. Now, the fallacy in this argument is, Your Lordship, I was appointed in 1990, prior to the enforcement of these rules. 2002. So Rule 7.2 has no application to me. In fact, Rule 7.2 is for persons who are appointed without going through the selection process. I have gone through the selection process. And so even if my case were to be judged by the rules of 2002, after it came into force, I am someone who was directly recruited in the year 1990. And as your leadership has already gone through the previous rule, Rule 3, persons recruited to this service before the commencement of the rules, they are a part of the service. Now, that is so far as the argument of the state is concerned. Therefore, to rely on Rule 7.2, 7.1, and say that I am an ex-cadre officer, that is something which is contrary to the rules. Now, the private respondent has relied on Schedule 1 to say that the post of systems analyst doesn't find mention, or assistant engineer, doesn't find mention in the Schedule 1. Now, the argument I was trying to make earlier, Your Lordship, as far as the revamping of 2011 is concerned, look at the category of posts. Respondent number 4 is under the impression that if just the designation is mentioned, it does not matter what the strength of the post is concerned. Though, of course, he relies on the strength of the post. Now, what does the rule say? There is director, one post of director. There is no post of principal director, which means, going by his own argument, the post of principal director is ex-cadre. It is not mentioned in the Schedule 1 of the 2002 rules. There are 3 posts of directors in terms of the revamping rules, revamping notification. Which means 2 posts of directors are ex-cadre. There are 4 posts of additional director in the revamping of 2011, which means 3 are ex-cadre. Joint director, there are many joint director posts, but your leadership will see in Schedule 1, entry number 3, nil in the grade of joint directors, which means everyone, including the petitioner, are holding ex-cadre posts, whoever is holding the post of joint director. Now, is that a rational argument, Your Leadership? Is that the rational argument? Firstly, the rules protect my service as ex-cadre, Rule 3.2. Secondly, the rules provide that the government may add or remove posts from the service. So acting within its powers, in the revamping exercise, posts have been created, including the post of principal director. If you have to accept the argument of both the state as well as the respondent number 4, all these posts are ex-cadre. In the second writ petition, Your Leadership, that was filed in the year 2020. It was in fact filed on 24/2/2020, much after the initial hearing of 2018. This is just an afterthought. Just an afterthought.
No, they have also stated that no,
Yes.
this will be infructuous.
So if they're not going to press it, it's a different issue, Your Leadership.
Yeah, I don't think you're not pressing it.
No, because law is very clear.
Hmm.
To oust him, he is no more there,
Yes.
so that will not survive.
We said that this is infructuous.
Then, Your Leadership, in the additional affidavit filed pursuant to 2018, Your Leadership will first see paragraph A, the first paragraph.
Additional affidavit.
Yes, this is filed on 12/11/2018. 2018.
Or that state.
Yes,
Hmm.
the additional affidavit which they were directed to file.
Hmm.
The post of page 2A, the post of Assistant Engineer Electronics, last one gazetted, which was upgraded to the post of Executive Engineer and designated as Systems Analyst, is not included as one of the regular cadre posts in Nagaland School Education Service Rule 2002, but the pay scale structure is equivalent to that of Deputy Director. Therefore, basing on the pay scale structure, the petitioner has been shown to be a Deputy Director in a notification dated 2/9/2009. This is all that is relevant to your leadership. This is all that is relevant. On this basis, the state has all along been treating the petitioner firstly in the grade of Assistant Director, secondly as Deputy Director, and thirdly as Joint Director.
But pay scale may be the same.
Yes,
Deputy
Your Lordship.
Director, but designation that they could not have put it as Deputy Director. Maybe Deputy Director / System Analyst.
Yeah, just a formality, your leadership. Just a formality. No, look at the language, your leadership. Please,
Deputy Director is
Please.
administrative
just
post.
a minute.
Isn't
just a
engineer is
minute.
technical post?
But the look at the language also, your leadership. Pay scale structure is the same as that of Deputy Director. But most importantly, your leadership, most importantly, in all the orders, earlier, prior to the interference by the association, I have been treated as Assistant Director, as Assistant and Deputy Director, and upgraded to Joint Director. Actions taken in the orders, what is stated in the affidavit, completely different, at odds, your leadership. Is that permissible? That too at the instance of a person who has no authority in law. At the instance of an organization which has no authority in law to question my appointment. That is the reason I was relying on those authorities, your leadership. The state cannot act in one way and try to justify it or say otherwise through the affidavit filed by them. But most important of all, your leadership, most important of all, the point is, in the additional affidavit which they filed, and I am very grateful to respondent number 4 for filing the additional affidavit.
Additional affidavit of respondent number 4.
Yes. Now, these are all from the records, your leadership. It's just that sometimes records are being ignored to support the respondent number 4. At Annexure A, at clause 5, yes,
PNR.
yes, the PNR itself says that I was regularized. My promotion to Joint Director was regularized against a cadre post. So
That's why I was asking the additional AG,
yes,
when you have been promoting him to a cadre post
Yes.
all along.
yes. So therefore, if I have been promoted to a cadre post as Joint Director, can anyone question my promotion to Additional Director? Because I am now at the stage of Additional Director, your leadership. I am not in the stage of Assistant Director or Deputy Director. We are beyond that stage, your leadership. We are beyond that stage. Now, the further argument has been taken that I am covered by the rules of 2002 and not by the rules of 2017. Now, firstly, much has been said by respondent number 4 about schedule to the rules, which shows that the post of Systems Analyst or the Engineering Technology Cell is the next cadre post. Page 11 of the rules. But the rule must be read in its entirety. Schedule at entry number 8.
Schedule.
Yes, schedule to entry number 8. The bottom of the page, entry number 8. Schedule 2 at page 11, page 14. Page 14.
Page 14 of this. new
No,
rules.
this is the 2007, the 2002 rules.
2002. Yes, that's
Yes,
number
8,
18.
serial number 18. May I read, leadership? Once the present incumbent officers holding ex-cadre posts are promoted, can you look at the word, your leadership? Are promoted or retired, the posts vacated by them shall cease to be ex-cadre posts. Look at the language, Your Leadership. The ex-cadre posts, those who are occupying ex-cadre posts, can be promoted in accordance with the rules. And once they vacate those posts, they will cease to be ex-cadre. Subsequent filling up of such posts shall be regulated as per the provisions contained in the rules. Look at the language of this schedule, Your Leadership. Those who are holding ex-cadre posts, they can be promoted. There is no bar to get them being promoted. If they vacate, the post they vacate will then be regular posts under the rules. So the whole intention, Your Leadership, is that those who are so-called ex-cadre, they are also entitled to be promoted under the rules. Where is the bar? So in terms of the 2002 rules, so that was why I was harping on the rules of both 2002 as well as 2017. There is no bar for me to be considered for promotion. And especially now, since I am in the grade of additional director, after being promoted to a regular post in joint director, pursuant to the revamping. Now, 2002 rules have been supplanted, have been repealed and replaced by the 2017 rules. Now, to say, Your Leadership, to say that I am still governed by the rules of 2002, that is, again, an argument which is not correct in law. I was still serving. Once rules come into force, the new rules govern me. If you are to accept the argument with respondent number 4, anyone who is appointed by the rules of 2002 will only be governed by the rules of 2002. That is not a valid proposition as far as the law is concerned. All those who are in service, when the rules are adopted, are governed by the rules. So therefore, if the earlier rules are repealed, they will be governed by the new rules. Now, what is the class of ex-cadre post as far as this rules are concerned? Again, Your Leadership, page 27. Page 27. All this planning, physical education, etc., they have all been brought within the rules. They have all been brought within the rules. At serial number 14. Has the Leadership got that?
Yes.
So it begins with, from the bottom, it begins at legal assistant, and it ends at joint director, higher ed, health education. This is also not in the systems analyst line or the engineering line. So if they are concerned, my learned friend was talking about the medics in the medical profession who are waiting in line. According to the rules, they are only entitled to be promoted up to joint director, health education. They cannot go beyond this. So even that concern is misconceived, if I may say so, Your Leadership. And insofar as Your Leadership, Schedule 1, which I was referring to earlier, and then the strength of the post and the argument that if I am not included in the strength of the post, so are the principal director, joint director, that Your Leadership will find in beginning from page 27 onwards from my writ petition.
Your writ petition.
Yes. 27, 28, 29, 30, up to 31. A large number of posts were created, including the post of principal director. And then one more, since of course some argument has been raised about my promotion order. In the reply to the representation, if we go to that again, Your Leadership, which is at Annexure I, page 73. This is the reply to the representation submitted by the ANSTA, All Nagaland School Teachers Association.
Reply by the government. That
Yes. Earlier, the one which I was referring to,
Yes.
Your Leadership. And this is 8 October 2014.
That was page.
Page 73. Page 73. The stand of the government.
Yes.
The stand of the government. This is subject, documentary evidences produced in matter of Engineer Lima Wabang's service in school education. 1, Engineer Lima Wabang has not come from the teaching profession, is correct. That is correct. However, it would be wrong to say that he is not an employee of the Department of School Education. Two, his name not appearing in the seniority list of professional cadre of officers does not invalidate his standing as a serving officer in the department. This is to counter the argument that he is not there in the seniority list up to 2011, Your Ladyship. Any officer, unless one has come to deputation or specifically appointed as ex-cadre, the remaining officers whose serving becomes a cadre member, including those officers who are observed from other departments, subject to the provision contained in the Department Restructuring Notification dated 21/7/11 and the Nagaland School Education Service Rules 2002. Annexure 5 of the Department Restructuring Notification dated 21/7/2011, the post of additional director shall be filled by promotion of a senior-most member from amongst the confirmed members of the ex-cadre from planning, health, and vocational education, and does not mention about obtaining a degree for BEd. So this is about those who are in technical posts. There is no requirement for them having the BEd. BEd, your Ladyship will appreciate, is only for those who are in the teaching profession, only in the teaching line. However, the last promotional avenue of Engineer Lima Wabang will be that of additional director till such time the Department Restructuring Notification dated 27/2011 is enforced. Now, this decision that he will not be allowed to be promoted ahead of additional director is taken away by the service rules of 2017 itself. The service rules of 2017 does not bar the petitioner from being considered for promotion. Then 5, 6, and 7, the Department Restructuring Notification dated 21/7/2011 has to be read with the Nagaland School Revised Rules 2002, and his promotion has been considered on the basis of the powers of the government contained in the Department Restructuring Notification dated 21/7/2011 and the Nagaland School Revised Rules 2002. So the department is also saying that all promotions are in terms of the restructuring as well as the rules of 2002. Then this is important again, Your Leadership. 8, the department seniority list of 2012 was published as a final seniority list, and based on it, officers were promoted within the provision contained under the Department Restructuring Notification dated 21/7/2011 and the Nagaland School Education Service Rules 2002. So this final seniority list has never been challenged by anyone, has never been challenged by them, the association. And this is the basis on which we were promoted.
Community list of
2012. Now, it is an interesting development as far as this is concerned, and I must place this before your leadership. There was a dispute with regard to in the grade of graduate teachers. In the grade of graduate teachers, not in the administrative level, in the grade of graduate teachers. And the dispute was with regard to whether persons could be given their seniority with effect from the date of temporary appointment. I was doing that case, Your Leadership. So ultimately, this 2012 notification was withdrawn and the 2015 notification was published, ultimately. But insofar as administrative officers are concerned, there was no challenge. There was no challenge. Just placing that on record, Your Leadership. Then at page 74, the Department Restructuring Notification dated 21/7/2011 cannot be read in isolation, but should be read with the existing rules, the Nagaland School Education Rules 2002. Since the senior most incumbents, Engineer Limba Wabang Iyer or Shri Polan Tep, have not retired nor being sent on deputation to another department, and the department being in dire need of senior officers and additional director being not the head of the department, but their services have to be used to assist the head of the department, the government reserves the right to use their services by promoting them to the rank of additional director, subject to the condition that no further promotion from the rank of additional director as per the Department Restructuring Notification 21/7/2011. Now, 11, 12, 13, of course, the latter part of the letter is against me. But the decision of the government, the reply of the government, that the 2011 rules cannot be read in isolation, that is one. That though my name does not find mentioned in the list, it is wrong to say that I am not an employee of the school education department. And then the mention of the seniority list of 2012, on the basis of which promotions were made. And finally, then, Your Leadership. Now, the last argument advanced by respondent number 4, though the respondent number 4 has no locus, and I still maintain that, Your Leadership. And all the arguments that the respondent number 4 is.
The officers are also there in that association.
No. They're not there by name, Your Leadership.
Not by name. of
No,
course.
it is just the association. There's a big difference in leadership. It is just, it is the association. They do not have any locus standi. To say that we have not challenged the seniority list of 2015, that is wrong. I have already referred the leadership to my prayers in the writ petition. I am saying that my categorization is ex cadre in the seniority list of 2015 is bad. Now, the last argument which my learned friend for respondent number 4 has raised is that I have retired, and that would mean that I retire in the grade of joint director, as that is my substantive grade. Now, it is this, Your Lordship, Your Ladyship. If those impugn orders had not been passed, I would my service in my promotion in the grade of additional director would have been regularized. First thing. Once my service in the grade of additional director had been regularized, as with other persons who held this post on officiating basis, my seniority or my rank in the grade of additional director would have counted from the date of my appointment on officiating basis. Can there be any argument against that? No, Your Ladyship. That is a settled proposition of law. If someone holds officiating promotion against a clear vacancy and is subsequently regularized, he or she is entitled to count his seniority with effect from that point. If my promotion in the grade of additional director had been regularized without any hindrance from the respondent number 4, I would have been considered for promotion to additional director. And if I had been promoted to the promotion of director, not additional director, I would have been entitled to the scale of pay and privileges in the rank of director, and I would have retired as director. And if I had been given these benefits, Your Ladyship, when the petitioner expired, his wife, his legal heir now in this case, she would have been entitled to all the benefits of the petitioner's service. So therefore, Your Ladyship, my humble submission and my prayer before this honorable court is that the petitioner has been wrongly denied his service benefits in terms of the rules of 2002, as well as the rules of 2017. And as such, an appropriate direction should be issued to the respondents for remedial measures. May I rest, my lady?
My lord, I'll just clarify one point.
I think you've said enough.
Yes, since he has referred to my additional fee document, he has read out only the document the sentence which support him. The rest I'll read it out. Now, the last argument is, Lordship is aware promotion is not a matter of right. So there's a lot of judgment.
Right to be considered.
The right to be considered, not a matter of right for promotion. That I don't need to dwell on that. Now, the annexure that my learned friend has read from my additional affidavit. See, this is all against him. If I read out, all against him, I'll read out so that Lordship will be cleared.
Your affidavit of 5th June.
Additional affidavit, which he has read only one para.
5th June 2018.
Yes, may I read it?
Yes.
Just to clarify the minds of the doubts of the court. You see, there was a dispute why he should be given promotion when he was ex-cadre. So that was referred to PNR. So PNR opinion observation is this. Matter has been examined and the following are conveyed. 1. The school education department had made a serious error in promoting ex-cadre official Engineer Mawapang Ayer to a cadre post of joint director. 2. This has been further compounded by the ensuing promotion sanction against the cadre post of additional director and allowing official in question continue holding the aforesaid cadre post. 3. These are grave infringements of the service rules of the department as well as notification so-and-so 21/7/11, saying the aforementioned rules / notification does not in any way provide for an ex-cadre official to be promoted and to continue holding ex-cadre post. 4. As such, the promotion of Engineer Mawapang Ayer against the cadre post of joint director and additional director needs to be revoked. 5. However, with regard to the promotion to the post of joint director may not be feasible to review the same, considering that it had been already regularized by the Department Promotion Committee, and also taking into account the fact that more than 4 years have been lapsed. This is human touch. 6 is against him. 6, as such, the present official promotion of Engineer Mawapang Ayer against the cadre post of additional director will have to be withdrawn, and in the event the department requires his service at the level of additional director, the department may accordingly submit proposal for upgradation of his post or promotion personal basis along with the compelling functional justification. So therefore, the post held by him is absolutely illegal as per PNA observation. This is what I want to clarify. Much obliged.
I'll keep this.
That's okay.
Oh,
My friend has already passed it on.
It will be returned, don't worry.
After a few days, the same similar case will happen from that rule. Challenging the rule.
Oh, coming up again. Head counsel for the petitioner, Mr. A. Zimomi, and Learned Additional AG Team Song for the state respondents, and Mr. Azo for the respondent number 4. Hearing is concluded, judgment reserved.
Much obliged.
और तो खत्म हो